Tonight's roll call, we have Ray and Rick excused. We have Lori joining us via Zoom. We have AJ and Stu is absent.
AJ did, he just emailed me too.
So he did email.
I can't read it.
No, I'm sorry, so I'm sorry, that's it, and I cannot make it.
So AJ just sent a message in, so AJ is excused.
Okay, well, Stu is absent.
And Stu is out.
Nobody's heard from him. All right. Well, hi.
Hello. All right,
Keith,
moving on to item number 1's adoption of agenda.
move to adopt the agenda.
Oh, I'm sorry. Did someone say something?
Yeah, I did, Keith. I had a hard time. I know is Stu, there's a possibility he didn't receive the link to the meeting. I had to go find an old link to get in.
Okay.
So if he was planning on zooming in, he might just be looking for a link.
Oh, did you hear from him, Lori?
I didn't hear from him, but I'm just saying
Oh, you had to use the old link,
I had
right?
to use an old link.
All right, thank you.
Okay, so our links didn't work, okay.
Thank you.
Thank you for that, okay, thank you. Okay, Stu will be a question mark.
I've got that.
Okay, thank you very much.
I do.
Okay, moving on to item 1, adoption of the agenda.
So move to adopt the agenda.
Second.
Diane. Thank you, Linda, all in favor?
I'm not even gonna try to second anything.
It's
That's
gotta be
unanimous.
fast.
Item number 2 is announcements. Do you have any announcements tonight, Tiny?
I just wanted to mention again, we've had a lot of questions about the STR committee. We have kind of looked at it, and in order to save staff time, we're going to do it as an STR task force. That way we don't have to have it recorded, just a little bit more casual, but we can still get all the same things done. There's just been a lot going on. We haven't forgotten about it. We will deal with it with the next meeting, the second meeting in January, which is the
23rd.
Thank you. Trying to do math. And if you are interested in being on the STR committee, please go to the website, click on, I believe it is opportunities, volunteer opportunities, then you, go ahead.
They can't yet because the task force hasn't been formed. I've been telling everybody, if you want to do it, to please just send a message to the board. We just recently got one.
Oh, see, I
Until-
do it.
Until there's a resolution,
Mhm.
there's no link on that volunteer form to put for the STR task force, but we have a whole list of people that have sent notices to the board.
We do, and so I just said, go with volunteer form and then put a comment in the comment section where you said, it doesn't allow me to be on the STR, but this is what I'm interested in. So either way, wait for the link or put a little note, but if you are interested, let us know. And we will be dealing with it at the next meeting. So thank you for all the interest that people have shown.
Thank you very much. Any other announcements? Okay, thank you, Tiny and Linda. Okay, hearing none, moving on to item 3, property owner comments. We have 15 minutes total, 3 minutes per person. Do we have any property owner comments tonight?
Please.
Sure. You just come up and you state your name and address, and then you have 3 minutes.
Great. My name is Jason Moschler, address 36 Louise View Drive. And I'm here representing the group Sun Valley Safe Cycling. And we recently just sent our proposal in to the board. And I'd just like to follow up that submission and make sure there's nothing else that we need to do. Whether it be work with Rick and Ray at Long Range Planning Committee. We understand there's some new news regarding creek setbacks and the potential location. We're looking at the location that Joanne had suggested. And so we're very eager to help. We're very eager to move and get shaking. We have a lot of able bodies and a lot of motivated individuals. So
One of the things in the packet that the board members got, there was supposed to be a drawing, I thought they
Okay.
mentioned, and I didn't see anything
Okay.
in that.
Great, I'll follow up with our group's leader, Dan Murphy. I know we have the drawing and I've seen it, so I'll make sure he resends that for everyone.
May I ask a question?
Yes, go ahead, Rob.
Yes, of course.
I'm Rob Gibbs. Just a question, is this, I didn't get a chance to really fully look at it, I did look at it.
Mhm.
Is this just a pump track with the banks and whatnot, that it's not some trail?
Correct, it's a pump track.
It's a pump track.
Yeah, and we met with a local excavator that lives here in Sun Valley too, just to get his opinion on the site. And then after he left, I kind of mentioned to those that were in our group, I've seen these things built by hand. We have 40 people with very good backs, and so like we could actually make it. It's not a huge scale, and it is scalable. You can add to it or take away from it easily. So
That's good.
yeah,
What was your name again?
Jason Bushler.
But
Spell your last name for me.
Sorry, Moeschler.
Okay, got it.
Jason, I just want to express my appreciation for you wanting to do this. I think it's a great idea.
Yeah, it's our group is actually very active out here after the windstorm. Within 3 days, I think we had 120, at least 120 trees cleared off of Rufus Creek, Bainbury, Cougar Ridge Trail, and also Repeater Road. So, and also probably some of the Sun Valley trails as well. So the group is very active. We have a lot of certified sawyers. We work actively with Whatcom Mountain Bike Coalition as well. And they encourage all of us that are using chainsaws to get certified. And so we're out there doing it safe. We really enjoy it. A lot of the group members like their chainsaws and are into their chainsaws as much as their mountain bikes. So it's kind of funny.
Now, when you get it done, I might have to drag my old butt up there.
Yeah.
So that's awesome, thank you.
All right.
well, thank you very much.
Thanks, you guys. Yeah, we look forward to helping communicate.
Thanks for
Thank
touching
you.
base again.
All right, of
Appreciate
course. Thanks.
Thank you, Bruce. Do you have any other property owner comments? All right, hearing none, we're gonna move on to our board orientation. Tonight we have Richard Davis with CSD Law. He will be doing our legal portion of the board orientation. He'll be starting and joining us first. So Richard, you can just come on over.
Richard, I'm gonna share the screen here.
Yeah, you
And,
you
want to sit here?
So, yeah, why don't we? Easier for you to sit here?
That's fine, yeah. It's easier if I can control, this stuff.
Sure.
Yeah, if that's all right, I'll give it my mouse. But I have to be able to see the screen.
Yeah.
There's this one or.
You want to come and sit there with me?
You want to use that or you want to?
I don't mind.
This is okay, can I control it from over there? No, you'll need to.
Go ahead.
Okay.
Thanks.
Just come right in and take care.
Never mind, that's the plan.
You can make it full screen if you want. Yeah.
Before
You
we
can
start,
look through there, you can
You
kind
say
of move
yeah.
around, and you can kind of look with Keith and. Tom has a comment before we start.
well, just a request, is it possible to get these recopied with a 3-hole punch, so we can put them in the binders?
Sure.
Just contact Diane.
Yeah.
Or just, give them to me when we're done with the meeting, I'll take them back to the office.
There's a wonderful
Have a punch
gigantic 3-hole punch down at admin.
Did you,
Yeah, you just
Okay,
make
so
sure-
everyone-
when I say.
Am I missing?
Did you load one I sent today? Yeah, that's it.
Does everyone have their updated copy?
There's actually,
Okay.
Tom, can you, yeah, it's just updated
This is the
from what you had.
updated one, right? You
Correct.
received today. So this one here today was updated today. So the one we have in our book that you previously received would be outdated.
Okay,
And there were some slight changes to this. I'm not exactly sure what they are, but this is the updated version that was printed and handed out tonight.
good, thank you.
All right.
There's lots of them here.
Oh, all right, thank you.
Do we all have
Tom, you
one?
want to throw one over here?
No, keep
Seven.
that.
One right there, Linda.
I'll borrow this one.
They are the one that's stapled there in the corner.
Thank
All
you.
right, we're all settled.
I
Everybody-
think everybody's got one now. That's here.
Perfect.
Okay.
And then we'll fall on the screen and go ahead. Richard.
Sounds good.
Sorry.
All right, well, good evening, everybody. Nice to see you for our annual training. We're gonna follow along the lines that we talked about last year, a few tweaks to things, and feel free to stop me anytime if you don't understand or have questions about anything. So I always start with kind of assumptions that I make whenever I do one of these presentations. I've been doing community association law now or work for about 35 years. So I've worked with a number of different boards, and every one that I've worked with, I have these kind of same assumptions. And that is that when you take the time to serve on a board of directors, that takes a lot of time and effort. Time that you could be doing something else with your family or hobbies or what have you. So I know that people are sincere about their reasons to serve on the board and to make the HOA a better place. So I always start from that assumption. I always assume that the directors are interested in a well-run homeowners association. They're interested in making sure that the community benefits, the community is getting what it needs. But I also assume that there's always some room for improvement. You could always do things a little better. There's, and hearing something like tonight's presentation may give you a few nuggets of things that you could do a little differently. Being on the board is not an intuitive process. There's no, it's not something that you just, innately what to do when you're elected. I've served on a few boards over the years, and my first couple of experiences, it was a learning experience for me. So I learned a lot just by being a director myself. All directors need to recognize that you're leaders here at Sun Valley and have to act accordingly. There's a higher level of responsibility that you have now. And then finally, recognize that I am going to talk about some legal aspects, but I'm also going to talk about some non-legal aspects of being a director at a homeowners association. And you're free to engage in a discussion about those and have a different point of view, because not everything I say there is legal. Some procedural things for this presentation is, we're here to kind of increase your knowledge and awareness of principles of serving as a director, what it takes to be a better director. This is not about, I didn't come in here with any preconceived notions that we're going to criticize, actions that have been taken in the past or criticize prior directors or current directors. That's not the purpose of tonight. It's just, this is a general discussion. Sometimes we delve into areas that are awkward to talk about. Social media may be one of those. We always talk about that every year. I'll have something to say about it again. But this is not intended to be this a discussion about any particular director's actions on social media or other kinds of actions. We're just here to talk about general topics, hopefully engage in a little bit of a discussion about that. So I always start with the legal concepts. These are kind of the things you need to know as a director. All right. What is Sun Valley? Well, it's a couple of things under the law. Well, it's first of all a homeowners association. There's a statute that applies to HOAs, and that's RCW 6438. In a few years, you will be governed by a different statute. But for now, until January 1, 2028, the HOA Act is the one that governs. The Nonprofit Corporation Act also governs the association. And that law was recently amended a few years ago. It used to be 2403 and in the RCWs, now it's 2403A. And it's a much more robust statute now. It was overhauled. It wasn't just, changed here and there. It was a complete and utter overhaul. Much better statute. So, sources of authority. You have those two statutes that I just talked about, but another statute. Yeah.
Yeah, just real quick, a nonprofit corporation, which I assume is a 501.
No, there's a difference there. So a nonprofit corporation just means you don't have any shareholders. Nobody has a financial interest in the Sun Valley. A nonprofit corporation just has members. And you're a member at Sun Valley just by owning a lot. You're automatically a member. There's no admission or application fee that has to be paid, just automatically a member. That's how Sun Valley is. Some associations do have kind of an application process, a little bit more detailed, but not here. 501c3 is an IRS designation that says that you are a tax exempt organization. And the beauty of that in part is that when donations are made to Sun Valley, those can be tax deductible. So that's an IRS designation that was applied for, and Linda will probably remember the exact date of when that occurred. But there's some work that goes into that, and then the IRS has to actually say, yeah, you meet the criteria for, is it 501c? It's
SC4.
four, yeah.
Mutual benefit.
And anything that's contributed to us is not tax deductible.
Richard, so anything, like when you said, donations are tax deductible, but that wouldn't apply to a sponsorship of, let's say, we want to do a 4th of July event and someone sponsored it and just gave the association funds,
It should be,
that would be tax
it should
deductible?
be,
Yeah,
yeah.
but we're a C4.
Huh?
We're a C4.
Right.
Right, okay.
Okay, so if someone decided to sponsor an event, some company, that would be a tax deductible.
They would want to talk to their accountant, because I'm not a tax lawyer, but that's my understanding, that it would be.
Oh, that's good to
Yeah.
know.
Yeah.
Thank you.
Non-profit.
The other law now that you're going to become more familiar with in the next few years is WCOIA. Currently, WCOIA, and what the statute is that it stands for the Washington Uniform Common Interest Ownership Act, or WCOIA for short. And when this law was passed, it was the hope of community association attorneys that all kinds of community associations would fall under the umbrella of WCOIA. Condominiums, cooperatives, HOAs, and so forth. The legislature didn't go that far. The legislature said you can opt into WCOIA, but you're not automatically governed. You're only governed by it if you're formed on, I think it was July 1, 2018 or later. And so Sudden Valley, not having opted into WCOIA, is only governed by 2 provisions of that statute currently, which apply to all community associations. That is, in how you adopt your budget, there's a process for that, which requires more than a majority of all members in the association to reject it. Otherwise, it's ratified. And there's assessment provisions in there. So if you know the history of Sudden Valley, it has, in fact, still has in its bylaws a provision that says in order to increase assessments, you have to have a vote of membership. So Sudden Valley had 2 votes that it would do historically. They have a vote on the budget, a vote on the assessments. Then there was a lawsuit that was filed against Sudden Valley, and we defended that lawsuit and went up to the Court of Appeals, and the Court of Appeals said, yeah, that process is legit. Well, that kind of put the community association world in the state into turmoil. I mean, there was a lot of angst over that decision. And what happened then is the legislature passed a law or provision in WCOIA to directly address the Sudden Valley decision. And it says to protect the public interest. These provisions apply to all HOAs in the state, no matter when they were formed. And so now when you approve your budget, it automatically approves the assessments that have been contained in that budget. So when you look at your budget, you see an assessment per lot that's listed there. That's because of WCOIA. And that's all that applies right now. But come January 1, 2028, the legislature just, I think it was the last legislative session, passed significant amendments. And one of those amendments was that all associations in the state will be governed by WCOIA on January 1. So the statute is a better statute. There are some changes that are going to need to be made. And what I'm essentially advising associations to do at this point is to start planning 2017 to amend your governing documents and get them updated and compliant with WCOIA. Because if you don't do that, you're still going to be governed by WCOIA. And if there's a conflict between your governing documents and WCOIA, well, it's going to govern. But the problem is nobody ever reads the law. Everybody reads the bylaws or the covenants that are on your Sudden Valley website. So there'll be confusion, right? And one of the reasons why we have in the bylaws, we still have that antiquated provision about voting on assessments, but I recommended that we put a footnote in there that says this is no longer valid. So that when members read that, they know, oh, we got this language here that it's been superseded by law. And so what I would recommend is when budgeting time comes for 2017, And I'm sure the document review committee will be active that year.
2027.
What I'm, 2027, I'm sorry, 2027, will need to be active in talks with us to amend your documents so that they're consistent with Wacoya. I don't think it's smart to do that yet, because there's still to be legislative changes this session, next session, before that actually takes place, on January 1, 2020. Linda?
Rich, there was a bill that passed, I want to say early last year, that a couple people referred to that took only certain parts of Wacoa and said they're not in effect as of June of 2024. It's a bill, it's like 5186. If you want, I will send you the link.
You don't need to send it, I don't know offhand. I do know that what has happened is parts of Wacoya have been incorporated into the homeowners association statute, condominium act, those things. So maybe that's what someone is talking about, but 6438 has been amended recently.
Oh, have they, because I know that they specifically, it's a bill that they just referred to, it's something like 5186, something like that. I will send you
All
the
right,
stuff
yeah.
rather than us wasting
I'll take a
time.
look.
Rich, I have a question.
Yeah.
So I'm kind of used to documentation that trees down. I think that's what these bullets are referring to. So our government, the legal sources start at this 6438 and then flows down through 2403 and then flows down to the Wacoya. Is that right?
Yeah, that's not exactly correct. What we try and do, well, if there's a conflict between statutes, what the court will say is, let's look at the statute that is most specific. So it depends on the issue. If it's about budget and assessments, for instance, then, 6490 would govern. But there could be a conflict between just the general, because there are many nonprofit corporations throughout the state, not just HOAs. Sometimes the HOA Act has something specific and it deals with a certain topic that is also in the Nonprofit Corporation Act. If there's a conflict there, then the HOA Act would control. So it really depends. You got to look at it on a case by case basis.
Okay, and so what is in, and I haven't read these to be honest with you. So 6438, what's in there? That I guess let me ask it this way. Why have 6438 and 6490? Why not just have one document? You know what I'm saying?
Yeah.
I mean, where do they step? Where do you step from one to the other? Because you're saying that in legal, the court would say, oh, it depends on which one, is the language is more specific to the issue. As directors, what is it that we need to know, and how do why not just have one?
Until you wake up on January 1, 2028, you really just need to focus on the HOA Act. Because none of the provisions of Wacoya apply other than the two that I mentioned.
Okay.
But on that date, then everything changes. What, the legislature just kind of chickened out when it passed Wacoya. It didn't bring everybody under that umbrella. But now I don't know what political, pressure they had, but it makes sense. Because we want consistency. There's really not that much difference between condominium associations, HOAs and the like. There's a lot of similarities, and so Wacoya will, apply to all.
So just one last follow-up then. So in 2028, there'll be less language in the HOA.
No, it's gone.
Oh, it'll go away.
It'll go away entirely.
Oh.
Yeah.
Okay.
And that's why I say amending your documents to ensure compliance with Wacoya makes sense.
Document review committee is going to be busy that year.
I won't be
So,
here.
put that in your budget.
I'm done.
I'll give you on that committee that year.
Rich, one of the things I think that I wanted to say, kind of to answer this question, and maybe I'm wrong, tell me if I am. Wacoya doesn't only include HOAs, it's condominium.
Right.
So I think the condominium 6434 and
And-
A38 are both going to be sunset. and they will be gone in 28.
You actually have two condominium statutes, depending on when your condominium was
Okay.
formed, and they all collapse into Woodcoya.
Cause I started reading that and going, wait a minute, I'd have to read this section that deals with condominiums.
So on this, oh, yeah, go ahead.
Yeah, no, just as a comment, I was going through the, our number has the bylaws of the RCRs, the first section of the new book that has the legal documents. Of what, and I'm pretty sure the disclaimers for budget and dues are already there.
Yeah, so footnotes are in there.
Yeah.
You need to know, and I think nobody does, when Sudden Valley was first, quickie, when Sudden Valley was first formed, we voted on assessments only. Then in 1995, that's when the state law said we had to do budgets and vote on budgets. And so that's why we voted and began voting on two separate measures, because we followed what we had always done since we were formed in the 70s. And then the requirement of the state in 95, that's how we got to. Okay.
So
This is what you can never leave.
That's right, that's right.
We got,
Because you know everything.
We have changed.
we have a lot of stuff to get through tonight, guys. Just
Okay,
so-
all right.
So all
Thanks, Steve.
all we've talked about on this page are statutes. Those are the things that the legislature passes during the legislative session. In addition to that, you have other sources of authority, like the court cases. So there are cases that are decided by courts about disagreements over statutes, disagreements over governing documents and the like. So those then are also a source of authority to Sudden Valley, but they're subordinate to statutes. Then you have your governing documents, your bylaws, covenants, rules and regulations, ACC policies, all of that kind of stuff. In the event of a conflict, that's kind of a hierarchy there. Statutes trump any cases that would be inconsistent. And then your governing documents are subordinate to all of that. Okay. And then in addition to that, you need to know kind of the hierarchy with respect to your governing documents. So this page just lays out what that is. You start with the plat map, which is the foundational document, your recorded declaration, and there's a declaration recorded against each division. But I think they're all virtually the same. And then under that is articles of incorporation, your bylaws, the procedural documents, and then the rules and regulations are passed by the board and any policies. Okay, let's turn to committees. So we've got a number of committees that are described in the bylaws, and really all I want to say here is there's a difference between standing committees, which are those that are identified in the bylaws as kind of more of a permanent committee that has an ongoing function that, you know, and so those are important enough to be identified in the bylaws. And what are their purposes? Well, they sometimes perform tasks that would otherwise have to be done by the whole board, like hearing appeals. You know, you have an appeals committee for that. They report to the board on a specific item and make recommendations. And as we've just been talking about with the document review committee, I assume that in 2027, that'll be the main body of work that they do, and they'll be making recommendations to the board for changes in the bylaws. Ultimately, however, even though the committee has this responsibility, whatever it says in the bylaws, the board's ultimately responsible for that work of the committee, right? And it needs to exercise oversight. So if a committee went off the rails and did something that could cause liability to Sudden Valley, the board would need to step in, and because at the end of the day, the board is responsible for what happens at the committee level. The bylaws talk about how rules can be adopted for each committee. Those rules are subject to approval of the board. Okay.
Quick, very quick, could oversight be as simple as regular reports from the standing committees to the board at a board meeting?
Yeah, I actually think that that's a good approach to kind of stay apprised of what the committee is doing.
Okay, thank you.
Ad hoc committees are those that are created on for a specific purpose, for some specific function that may not be something that occurs on a recurring basis. You know, you have a discrete issue that comes about. If it's going to be ongoing, if it's something that really needs some permanence, then it probably ought to be a standing committee. Ad hoc committees, again, I think there's some controls that ought to be put on those committees so that for the benefit of both the board and the committee itself. And that's usually done through a charter that describes the scope of what the committee is going to do, how long it's going to be in place, what deliverables it's going to give to the board, if any, and what kind of procedural rules are going to govern that committee. That way, the committee members who are assigned to that, they have clear direction, which is what they want. And the board knows what they're going to get from this committee and when they're going to get it. I always suggest reserving the right to the board to disband it if it's not functioning as you expect it to do, if it's not giving the deliverables, not reporting to the board, whatever the case may be.
Just a question on that. We were talking about the STR. I think you referred to it as a task force, maybe?
Yeah.
Would that be-
Yeah.
Would that be an ad hoc committee, or is that too formal for what we're considering?
Well, it depends on what it's talking about. It may be just reporting to the board on what kinds of, like, for instance, if the question was, what limits or what limitations can we impose on short-term rentals? That's probably an ad hoc committee. It's not an ongoing.
Right.
But, you know, it's really just investigating under your governing documents, what can we do?
Your options.
Yeah, what are our options? Yeah. All right, then we turn to the board of directors. All right. Directors are those members in the community who have chosen to be leaders here at the association. I respect directors very much because, as I said before, there's a lot of work involved behind the scenes. It's not just showing up here at a meeting, spending a couple of hours at a meeting. There's a lot of background work that has to be done. You need to prepare for the meeting. And members don't often appreciate that. So I say volunteer gig, all the work, none of the glory. It's just the nature of the beast, right? It's important work, it's necessary work. But if you came here to get accolades from the community, that's, you know, probably not going to happen too often. Directors need to focus on governance in order to be successful. And there's a real difference between governance and management. And when I was sharing this presentation initially with Michael, Michael mentioned, and I just want to mention it's not in the PowerPoint, but there is, to the extent you're interested about this area of management dichotomy versus governance, Carver, what's his first name?
John and Miriam.
John and Miriam.
Two people, it's the Carver model.
Yeah, there is a lot of information on the Carver model, which, you know, goes into a lot of what I go in. I mean, I'm just going to touch on it briefly tonight, but it is you know, a very in-depth area, and it's useful. And if you, to the extent you want to read about that, there's a lot of materials out there. I encourage you to kind of look into that. I'm sure Mike probably has those the links available.
It concerns all corporate governance, but there's a lot of specificity for home associations too.
One of the things I would say is your overall goal is, because this is the foundation on which you work together well and you can make good decisions, is establishing a culture of trust so that the community trusts you and your bank of political capital gets built up, respect for each other, respect for differences of opinion, and dignity. And those things can be hard sometimes when people are passionate about issues, but it's important to recognize that that really is the foundation for the work you do here. Let's talk about legally, what do you got to do as a director? You have a standard of care that is imposed on you by statute. And in the Homeowners Association Act, it says you have to exercise the degree of care and loyalty required of an officer or director of a nonprofit corporation. That's not very helpful. So then we got to go to nonprofit corporation statute, find out what that means. And what we find there is that you have a fiduciary duty. So you have to act in good faith. That means, you know, you have to act with honest motives. If you have, for instance, a conflict of interest, if you're voting on something that you are personally going to benefit from potentially, then you need to announce that. Maybe even recuse yourself from the vote or not engage in the discussions. Act in good faith. Act with the care that an ordinarily prudent person in a similar circumstance would act. So if that means, gosh, this is an issue that really requires some expertise that we don't have, we need an accountant, or we need an engineer, or somebody, or a lawyer, then act with that. If a normal person would seek that kind of assistance to make a decision, then the board should as well. Act in the best interests of the corporation. And that essentially means you are looking at the best interests of the corporation now and into the future, and not the best interests of individual members of the community. You represent the entire community here. There might have been a segment of the community that was really in support of your campaign and that helped you get elected. But now that you're here, you're representing the entirety of the association. So the other duty that came about through the amendments to the Nonprofit Corporation Act was a duty of disclosure. And that means that if you identify an area of concern, liability to the association, you have a duty to tell the rest of the board about it and not hold it secret or talk to others about it. You actually have to bring that up to the board. Now you are, as a director, as I said, you're entitled to rely upon others. It's called the business judgment rule. And it basically says you're not liable. No member could sue the board or an individual director, say you made a bad decision, if you have relied upon an expert, maybe the expert got it wrong and gave you some bad advice. Doesn't matter. You relied upon an expert, someone who had the skills and education to give you advice, then that protects you. So your standard of care, just to boil it down, is this: act like a reasonably prudent person would who's in a similar situation. Retain your outside expertise and consultants when it's necessary to make an informed decision. Disclose to the board information that's relevant, of concern or potential liability, and completely understand the issues and the risks before you take action. And that means sometimes you may need to table the matter to get more information because you don't have enough information yet to make an informed decision. Okay, board meetings. Board meetings are for the board to conduct its business, right? And you've got limited time here because all of you, none of you are paid employees of Sun Valley. You're part-time volunteers. Your time is scarce, so you want to make it as productive as possible. Your minimum requirements for a valid meeting are you got to have a quorum present. That's defined as a majority of the directors at the beginning of the meeting. And as I recall, I didn't double check this, but I believe your bylaws say you lose a majority during the meeting. I could be wrong. You can.
I was gonna ask, because that came up right before you got here. When it comes to a quorum, Daniel and Rob are directors, but they're not voting directors. Do they count as part of the quorum or not?
I actually have to look at the actual language in the bylaws.
That's a good question.
Yeah, I can do that. Carol, would you just take a note for me to look at that? I'll get back to you.
So you have a quorum, you have, if everybody's available at the beginning, but if after people leave, what can you do in the meeting?
Well, it depends on what didn't go back and check your bylaws, and that's important to do because even
Specific.
sometimes the bylaws are drafted that if you have a quorum, it sounds like they are. You have a quorum at the beginning, then you have a meeting and continue to conduct business, even though you lose that quorum.
Yeah, okay, and vote and everything. Yeah, okay.
It would seem strange that Daniel and I can make motions. We can comment on motions. We can't vote, but we don't count for the quorum for conducting business. It just would seem very odd to me.
Yeah, Linda's going.
My bylaws. That's my duty. Smacker. It says under section 11 of Article 3, a quorum of the board. At all meetings of the board, a majority of the voting directors shall constitute a quorum.
Okay,
So there has to be at least 5 plus here voting directors,
Interesting.
Okay.
where there's 9.
I thought that's what it was, but I thought it was worth checking, so thinking of that.
Okay, thank you. Okay, so, if you don't have a majority, at the beginning of the meeting, you don't have a quorum, you can't take any action. You need to comply with the scheduled, notice requirements for meetings and prepare minutes. And then the minutes are prepared after the meeting and approved then ideally at the next meeting of the board. The minutes, you know, there's a lot of debate amongst various associations about how detailed those minutes have to be. My own personal view is what people say during the discussion, how you wound up making your final decision is not very relevant. What the relevance is, what official action did the board take? Because that's the official action of Sudden Valley. We want to be able to refer back to that and not have it watered down with a lot of, well, here's what this director thought, and here's what that director said during the meeting. So that's my view of things.
Well, that's a question, I think I asked you this last year, our architectural committee, we meet before we do our tours of all the properties, and we do sit down and sort of discuss, you know, which properties we're gonna look at. No decisions are made, we talk about them, we give our opinions, but no decisions are ever made on that.
Yeah, I can give you a comment, section 2 on losing the quorum. So it does say a meeting in which a quorum is initially present may continue to transact business notwithstanding in spite of the withdrawal of directors, if any action taken is approved by at least a majority of the required quorum. So it sounds like you lose the quorum, you can't really take any action after that.
Sure.
Yeah, that's section,
It
yeah,
sounds like you
I
need a
read-
quorum of 5, and then the majority of the required quorum, so if 3 are left, you can still make a decision.
no, it's saying of the required quorum, so the required quorum would be 5.
Right.
You can discuss, you can continue, but if you take action, you're gonna need to have the original quorum present. That's my interpretation. Would you agree with that?
I think so.
Is that in our policies or?
That's in the bylaws.
Well, that makes sense too, because if you would need a,
Section 11.
the quorum
That'll-
it would constitute the voting members of the committee. You would need at least a majority of those folks to make decisions and to get the
So-
meeting going, so it makes sense to me.
You have 5 that's needed for a quorum. is that
Yes.
right?
Yeah,
Yeah,
for the board.
5 of 7.
yeah, I think you're right.
Yeah, and if one director has to leave and you're down to 4, you can continue the meeting, but you can't take action on any
Yeah, well-
issue. You lost the quorum at that point.
You have to
But
take.
what about ACC is what Daniel's interested in? Like, we wouldn't do that, but he's more concerned about ACC. How is that gonna function for him? Like many times in ACC meetings, you have you're struggling to get the quorum and then somebody's just calling in to make the quorum and then they leave. You're voting on everything on the ACC agenda as a vote.
Yeah, I'll come down to the committee.
You gotta go to that part of the
Yeah,
bylaws.
exactly.
I mean,
Well, and then my question is, the presentation notes ACC. I think the nominations and election would fall under the same suit.
Yeah, it says no business shall be conducted unless in the quorum of voting members present in a committee. So the board is authorized to organize committees to perform certain tasks. A minimum of 4 meetings held a year, notice shall be posted, no business shall be conducted with less than a quorum of voting members, and minutes shall be filed with the secretary. So,
That's the ACC section,
Yeah.
Michael?
Yeah, that's all of the.
It's kind
all
of
the
like there's a
standing
basic
committees,
section.
Right, so if you lose a quorum, you're the same situation.
Okay, good to know, thank you.
Right.
But about these aren't our actual ACC meetings where people show up and we go over the agenda. Or we run through the agenda, but this is a meeting that we have before we tour properties.
Mhm.
So we can prepare for our meeting.
Mhm.
No
You're not-
decisions are made. And we don't do minutes for that. It's very casual, we just sort of prepare our tour.
Yeah, no actions to be taken, it's just for purposes of preparation.
Yeah,
Yeah.
I don't think.
so that's not a biggie, it's whoever can come,
Yeah, in any
since
event,
you're not conducting business.
that's correct.
Yeah, I agree.
It's that word conducting business.
You probably even have some members that go out and do their own tour if they
Yeah.
can't make the main one.
Okay, So with regards to the board, then, your official actions that need to be reflected in the minutes are any motions that you make and any resolutions. Again, I think brevity in the minutes is kind of the better approach. And you can, I say here, record names that vote affirmative, negative. You can do that. You're not required to do that. Sometimes it is helpful, and people like that because you know, you have a term here, and at the end of your term, if you want to run again, you know, the membership may want to know kind of how you voted on certain issues. So that's an issue for the board to decide whether votes are going to be, whether the names of who voted what are recorded in the minutes. It's not a legal issue, but it's something to think about. Robert's Rules of Order, some kind of parliamentary procedure is, it's not required, but it's best practice. It should be followed. I know that Sun Valley does, so I'll leave it at that. Remote meetings. Well, we used to, during COVID, be familiar with all meetings being remote, and now we're back in person, which I frankly think is an advantage. It's always helpful to see people in person, but the statute, the nonprofit corporation statute allows you to have meetings remotely. In other words, fully remotely by Zoom, unless otherwise provided in the governing documents. Well, Sun Valley's governing documents do have a limitation on that. It says that remote meetings are allowed only in exceptional circumstances. And that could be, for instance, where you have a snow event on the night of your meeting. Roads are very snowy, be dangerous to come. You have, and so you wouldn't get a quorum, and so you call an emergency, and everybody attends remotely in that event. That would be an example. Having said that, the other thing I should say before I move on is directors can attend remotely. I know you do that. There's nothing wrong with that. Just recommended that the remotely attending directors are set up in such a way that the people who attend from the community can hear everything that remote director is saying. Okay, open session. So your board meetings are open for observation by owners and their agents unless there's a reason to go into closed session. Same thing with ACC meetings. They're to be open for observation. Minutes are kept regarding the open part of your meetings. They're not kept for any closed sessions. My recommendation is avoid offline meetings. And what do I mean by that? I mean meetings that are essentially conducted by email or telephone outside of the ordinary board process. You've heard me say it before, I kind of liken this much to the Open Public Meetings Act, which applies to public agencies. It doesn't apply to Sun Valley, but I think that, you know, when you look at the purposes of the legislation for the homeowners associations, they really do want the members to be able to see what's going on, what the directors are doing. They want to be, you know, the membership should be able to see all of that. And so it's not a good practice to have offline meetings, and it really destroys the trust the membership has if they find out about that kind of stuff. Closed sessions, you can go into closed session for a variety of reasons I'll talk about in a second. The prerequisites for that are you have to have a majority vote of the board to go into closed session, and there has to be an authorized purpose. The best practices are, once you get into closed session, it sometimes is tempting to kind of, the discussion may start to veer outside of the authorized purpose. Stop the discussion. You should not talk about anything that's not what you told the membership you're going to talk about in closed session. Keep it limited to that. And then you don't make motions or take votes in closed sessions, but you can give direction. And it's very common to give direction to the general manager or attorneys in the room, to give direction to the attorney on a piece of litigation, things of that nature. That's all well and good. So why can, yeah.
I just had a question. Are remote sessions available for closed session?
Yeah, so when you have a closed session, you can have people attending remotely. And in fact, if your whole meeting is remote, because a snow event, let's say, you can still do a closed session. The challenge is that I always worry about directors who are attending remotely that aren't on camera. If they call in, then you can't guarantee confidentiality because there could be some, if they're on a speakerphone, for instance, could be somebody else in the room. And that is completely anathema to the idea of a closed session. So, I mean, you could say, yeah, you can join remotely, but you have to be on camera, you have to be on Zoom, you can't call it. I mean, you could have some prohibition like that. There's no guarantee that somebody's not out of view of the camera either, right? There's always a concern, but I always, whenever that happens, I don't think it should be offensive to anybody. I think the chair should just ask, are you the only one in the room? Ask the directors who are remote to just get a verbal from them that they're the only ones there and confidentiality can be maintained. So your reasons to have a closed session include personnel matters. We got disciplinary issues or review of the performance of an employee, talk about it in closed session. If you want to talk with your legal counsel, or if I send you a memo and you just want to talk about the memo and you don't need me present, you can do that as well. You don't need me here. That's unlike a public agency who has to have their lawyer present. So you've got a little bit more flexibility. You can talk about litigation, either active litigation or litigation that's threatened or potential. Violations of governing documents by members, or if Sun Valley may have some liability to an owner, you can talk about that in closed session. Just some frequently asked questions about closed session. You don't prepare minutes, right? Why don't you prepare minutes? Because this is to be a confidential communication. And so you don't want to have any written record of the proceedings. If you want to take personal notes for your own kind of, purposes, that's fine. It's not an association record. That's just for your purpose. Can board members participate by phone? We just talked about that. Sure they can, but I would say just verify confidentiality. You can bring in outside parties to the closed session without violating the rule on closed session. For instance, you most always will have the general manager in closed session. Or you may have other consultants who come in to help the board make a decision that you're discussing. That's not uncommon, and it doesn't disturb the fact that it's a closed session. Finally, can you disclose information that you learn about in closed session to others in the community? The answer to that is a very clear no. The whole reason that we're here and not having a discussion in front of the public is because it's to be a confidential communication. And so you can't, you have a duty not to disclose that information. Yeah.
One of the things that we do, and I just want to make sure that this is okay. There are times when we vote, and I think you've put together some of our measures when we come out of closed session, where it really does take a vote of the board. But then we will say coming out of closed session, and then we will make that motion. And if we don't do anything, it's stated that coming out of closed session, there was no action taken. That always goes in our minutes. Is that okay?
Yeah, that's fine.
Yeah, just checking.
Yeah. That's pretty common to have some statement like that. So again, don't be tempted. There's always, I think some people are tempted to, they've got close friends in the community, they've got kind of juicy news, because things in closed session are always juicy, right? And sexy, and there's always a temptation to want to talk about that kind of stuff. Don't do it. First of all, not only does it violate your duty as a director, but it really undermines the purpose of having a closed session in the first place. If I'm a director and I know that what I say in closed session is going to be leaked, but if we've got somebody, I don't know who it is on the board, but stuff is getting out into the public, then I'm not going to be candid with my comments. Right? I'm not, and that really undermines why you're there in the first place. The other thing that it does is it doesn't allow the board the opportunity to present a clear, unified message to the membership. Sometimes an issue is being worked on. It takes some time. You may need a couple of closed sessions to really work through it. In the meantime, if the word gets out to the community, it's just blown the opportunity for the board to really coalesce with, with a consensus on that and to explain it to the membership. So it's really just, it's a sign of a dysfunctional board when you have leaks from closed session. And apart from the duty itself, it's just a bad practice. You can use closed session for appeal hearings in order to deliberate, the appeal itself would be could be in open session, but with closed session purpose would be to evaluate that and to reach a decision. Okay, so now I'm gonna move on to sort of the non-legal part of the presentation. And the thing I want to say here is this is great to have this kind of annual orientation. I think I really applaud Southern Valley for doing that. I know it's costly to bring me out here and do this. I think it's always good to hear this kind of stuff, but it's one step, it's one thing. And I put this line on here all the time because I really like it. I'm kind of an active fitness guy, and here are people going to the fitness club and yet they're taking the escalator as opposed to taking the steps. And what the point here is, you got to be thinking about this stuff all the time. Right? It's not just, well, let's see Davis in January and then we're good to go for the year. It's like, if you see the ship listing in it mid-year, don't ignore that. Don't wait until January to, have another orientation. Deal with the problem. This is something that has to be worked on continuously. It's like any business, we have a law firm now of probably close to 30 employees. Things don't go swimmingly all the time. We have personnel issues. There's little righting of the ship that has to be done all throughout the year. And it's the same with a board of directors. You just have to monitor it and deal with issues before they become a big problem. So how do you work together to achieve better results? Well, first of all, focus on culture. And you could consider documenting that. And I know I've talked for many years about a code of conduct. I don't know if you currently have one. If you do, okay, great. The thing about a code of conduct is the directors agreeing, these are principles we're going to live by. This is what we think it's important to do when you're a director here. You take on a certain degree of responsibility and we want you to abide by that. I like to tell the story of our firm many years ago. We had staff that were just really unhappy with us. They would, kind of sigh when you give them a project and roll their eyes. And we were so concerned, we hired a consultant to come in and figure out what the hell was going on. And the consultant talked to everybody and then came back and told us that the three shareholders said, no, the problem is, it's you guys, you're the problem, and your culture here is terrible. And it's trickling down to staff. I mean, they don't like it. You walk in, you ignore them, you don't say good morning, you don't thank them for their good work, they don't feel valued. Well, it was an eye-opening experience. I mean, that happened, gosh, 25 years ago, and it stuck with me. It's an important thing to set a culture. If you don't do it intentionally, it'll happen by default. And that's when a culture that's not very good usually gets established. So document the principles to which you'll adhere. And things that should go into that, I haven't looked at this code of conduct, but things like maintain information that's confidential. Refrain from questioning the motives of the other directors. I mean, there's a temptation when there's a disagreement. Well, there must be some ulterior motives here. That's rarely the case. I'm not saying it can never be the case, rarely the case. Come to your meetings prepared, read the packet. If you need to ask questions of the GM in advance so you can be prepared or you need more information, make that query in advance. It's disrespectful to your other board members to have to get up to speed here on their time if you haven't read your packet. Show respect for other board members. You can have disagreements, but you can have them respectfully. And outline expectations for engaging on social media sites, which is, we all know there's a robust social media presence involving Sudden Valley. And one of the things I appreciate those folks who responded to the questionnaire. It was actually fairly helpful for me to understand kind of how different people see social media. I've never, maybe with rare occasions, have actually been on any of these sites, but my limited experience with social media is that there's a lot of negativity out there. There's a lot of misinformation, disinformation, and things take on a life of their own. and I'm not gonna put anybody on the spot here, but one of the comments that was made that I found really interesting was, I like to monitor social media because I like to know what the community is interested in and concerned by and what information they're getting third hand. That's very helpful to us as a board because then we can address that. If there's a story that's running amok out there that is not true, we can actually take some action. But the same individual said, I don't get involved in those those kinds of discussions online because it's a no-win situation. And the other thing that it does is it doesn't allow the board to speak with one voice. You have individuals who may be speaking to an issue with, not a uniform message. And in my view is that if it's important enough of an issue to address, why not have the association address it? Does it have to be the board? Not necessarily. Last year, I actually threw out a suggestion, I don't know if you remember, is having someone who is designated on staff to monitor social media, and when an issue is identified, hey, this is getting out of control and it's wrong, let's put a statement on our website or send a message out to membership somehow that is a message that sets the record straight. So that we, because we want to talk to the community, we want them to be informed, but we also want them to have the right information. And social media tends to distort and kind of go down rabbit holes. So that's my view on that. I think whatever the consensus is on that, I think it's a good thing to put into a code of conduct. So what happens when culture breaks down? And we've had culture breakdown here at 7 Valley before. Well, my firm benefits from that, and I don't like that, and I don't want that. I don't like to be called for internal squabbles. It's not satisfying, and it runs up 7 Valley's bill. And at the end of the day, we want to provide cost-effective services to 7 Valley best we can, and that hopefully focus on legal issues. Right? The community also suffers when the culture breaks down, because then the board starts to bog down and personal grievances and such, and then you don't really get to the policy issues that you need to. And frankly, people, look at your meetings and say, well, why would I want to be on that board? So it hampers your recruiting efforts. You've had recruiting efforts or challenges in the past. So when the board is well functioning, people say, I want to be on that board. I want to be part of that. I mean, they're really doing things. So it really is a big deal. The other thing that it does is your culture will trickle down to the story I just gave you about our firm. It does here with your staff as well. Whatever culture, then the staff watches. Maybe they're not here tonight, but the staff is watching with the board and they're hearing what is happening at the board level. You can find it harder to recruit and to maintain good people if you have kind of a dysfunctional culture. And finally, when you have these kind of personal squabbles or resentments, then consensus just gets almost impossible to ever have. And consensus is one of those things where, it's fine to have a divided vote, have, a 5-3 vote, whatever the case, but when you have everybody in consensus, that is a very satisfying thing. And so it all starts with the board's culture. Now, what happens when it goes off the rails? How do you reset that? Well, first of all, as I said, don't ignore it. Don't wait for the next training. Because what happens, it's like a marriage in a way, and you all are meeting together and resentments can build up and they take on a life of their own. And then a couple of months later, you don't remember how it all started. You just know you don't like that person any longer. Don't let that happen. You can do a variety of things. You can schedule retreats, talk about the issues out in the open. You can have a consultant come in who has experience with nonprofit corporations, help you work through those issues. The key is communication. It really is, and get the issues out and get them resolved. I know that things like this can have a financial commitment. Having me out here tonight is a financial commitment. View that as an investment in your future. But you have to spend money. If you have to spend money to have the board become more functional, it will pay off dividends in the long run. All right, so now we turn to governance versus management and best practices. Why do we even focus on this? Why do I devote a third of my presentation to this? I think it's because it is the key thing to being an effective director and having the board really do what it needs to do in order to move the association forward. Sun Valley members actually expect the board to tackle these big policy issues. You know, if they see the board getting down to the nitty gritty on management stuff, they're gonna think, well, why are they spending their time on that? Why are we paying our staff when the board's gonna do this work for us? I think it preserves the political bank account that you're developing all the time by seeing the board really focusing on these large issues. So I'll talk about what governance is in a bit, but let me just kind of give you this. Because you're a volunteer, your time here is limited. And that means that you're only going to get to talk to the rest of the board during a board meeting where there's a, where there's quorum and you can actually talk about an issue. Statute says you shouldn't have offline meetings. Moreover, this is a valuable opportunity for staff who wants guidance from the board. And without that guidance, the general manager can't do his job effectively, and the general manager can't delegate work to his subordinates effectively. So this is valuable time for everybody, and it's limited. So have those meetings be effective. Don't waste a bunch of time. Have them be run well. So, and I say this every year, but it's worth remembering Parkinson. C. Northwood Parkinson was a British historian. And he wrote a little book back in the late 1950s. And it's a very interesting book. And his first law was that work expands to fill the time for its completion. We all know this in our daily lives. And same with a board meeting. If you had 2 hours of a board meeting and very little to deal with, it's very likely you'd fill up that 2 hours. It's just the way we tend to operate as humans. But the corollary to that rule is even more important for boards, and that is, the time spent on any item of the agenda will be in inverse proportion to the dollar sum involved. The example he gave was a board that had 3 items on the agenda. The first was an atomic reactor. Of course, there had been a study done and a report made, and there was a motion to approve the atomic reactor. And nobody understood anything about atomic reactors, but we had consultants for that. So that took the grand total of about 3 minutes, and that was approved. The next item on the agenda was a bike shed. Well, the bike shed had a total cost of about $5,000, but there was disagreements about what should materials be comprised of. Should it be a steel roof? Should there be a wood roof? Should it be enclosed on the sides? Should we even have a bike shed at all? I mean, why can't employees park their bikes outside? So that developed into a lengthy discussion, took a half hour for a $5,000 expense. But the final item on the agenda was refreshments for a particular committee. And the question was, well, what kind of refreshments are we talking about? Well, it's coffee. Well, now everybody has an opinion on coffee. How it should be brewed, what brand of coffee? Should we have latte? Should we just have drip coffee? Should we have coffee at all? Everybody had an opinion. And the meeting ended after a lengthy discussion with direction to the staff to investigate that issue more fully and bring it back for a decision at the next meeting for $75 a month. Now, this was a hypothetical, of course, but the point is, you can go down these pathways, and I've done it on a board myself, and then all of a sudden you start to think, why are we spending, somebody will say, why are we spending so much time on this? I mean, it's ridiculous. Or something that's so small of a matter, and shouldn't we leave that to our staff, our general manager to deal with? So keep that in mind as you serve on the board. What do you do in order to be an effective director? Recognize that you are leaders of the association, and people do look up to you. They expect you to have certain information. They expect you to have a leadership role here and to actually be active in the role as a director. So don't be a spectator or a critic, but take an active role here and contribute. You were elected to contribute, and that's what you should do. Do no harm. So Keep that in mind as you're scouring the social media sites and other things, is do no harm to the association. If this is something better that maybe the board should do, or the general manager, bring that back to the board for discussion and action. As I said before, be informed so that when you come to a meeting, you don't waste everybody else's time. And then also be accurate. When you are out in the community, be accurate in the things that you disseminate to the community. Accurate in where the board is at on issues and what the association is doing. And don't, of course, talk about confidential stuff. As a director, govern before you manage. Sometimes I've seen it happen on the board where the light goes off and somebody says, "Aren't we really intruding on the GM's role here?" I'm like, "Oh, yeah, we are. Let's back up, figure out what the policy issue is. Let's decide that, give the general manager some direction and move on." And so govern before you manage something. Watch what you say. One of the standards I like to use is, if I said this and it wound up in the newspaper the next day, would I be okay with that? Yeah, and that goes for your emails, it goes for the things you say at a board meeting. Watch what you say. Or when you're going to participate in social media, then watch what we say there as well. And then, as I said before, set a culture that's appropriate. What should you not do? Freelance. And what I mean by that is where you decide, well, I'm a director and I'm going to take, and I see an issue, I'm going to take some steps to address that on my own. I'm going to talk to some folks in the community and get this moving. And so you're doing that without any delegation of authority from the board, or trying to move something along, and that is not a good idea. The board needs to address that issue and decide who's going to take the role on this. Ordinarily, it would be staff rather than an individual director, but sometimes, particularly if there's let's say, outreach that needs to happen with the county, for instance, maybe we're going to send one of our directors over along with the general manager to meet with the county representative. So don't freelance. Let the board make the decision on who should address something. Talked about meeting offline and social media debates that happen. I think I need to say anything more about that here. On the next slide, avoid undermining the board. And so, again, social media can come up with this where, you have discussions online that really the board or the association as a whole should be communicating to the membership. Bring issues and concerns directly to the attention of the board rather than talking to members of the community about those or to others. And then I think one of the more important things is, once a decision is made, you may be on the winning side or you may be on the losing side. And it's tough when you're on the losing side, particularly if it's an issue that you were really passionate about. But you have to understand that decision is by default the correct decision, because it was a decision made by an informed board after a full and fair discussion of the issue. So you have to respect that decision. Where we have had some problems, and every association goes through this, is where you have a director who was so passionate about that decision and is bitter about having it gone the other way, to go out and criticize it in the community. That undermines the board. That does not help create a good culture. Do not do that. I once remember one of the founding member of the firm, French Mellick, who was asked a question, how was the attorney for the Court of Bellingham so long? And that was his answer. It's like, the commission always makes the correct decision. And that means I have to follow that. I have to honor. I may have made a different decision if I was on the commission, but I have to follow it, and the executive director better follow it too. We have an obligation to do that. Until it changes, that's our role as attorney, general manager, staff, and other board members. Respect the decision. During meetings, so take the time to state your views, but do it diplomatically, and don't make personal attacks on others. There's ways to debate issues that are appropriate. There's other ways to attack people, attack their motives, that kind of thing. That's the way that is not going to move things along. Look for those decisions that are important to you. I'm not suggesting that you have to weigh in on every decision that comes before the board. You have to articulate your position on that. Not everything's gonna be important to you, but look for those that are and contribute. Let people know when you thought a certain way, but they kind of convinced you that maybe a different way is better. Let them know when you compromise or you trust their judgment. That really is kind of a glue that brings the board together, and you'll find that others start to reciprocate. Support the decision of the board, so once the debate's done, it deserves your support. And then finally, recognize no decision is, except maybe rarely, is so important you would allow to fracture the board, right? So don't undermine the decisions that are made. Now I want to talk a little bit about the roles of the individual. So the president of the board has a very special role in that the president governs the meetings, and in that role has to ensure that everybody has a chance to participate. And sometimes an issue is a hot topic and everybody wants to talk. Hands go up all at once, and it's the job of the chair to make sure everybody has a voice and can speak once before we start giving people second bites at the apple. Sometimes there's no discussion, right? And there's just silence, and there's an obligation, not an obligation, but a challenge to try and draw out opinions. What does the board really think about this? The chair is always trying to seek consensus, and here, let everybody get their thoughts out, but at the end of the day, try and bring everybody together if possible. It's a hard job because, the president is looking to have everybody involved, but the president also has their own views and wants to take a swing and get their thoughts in. So you have to hold back a little bit, but that's part of the role. And I understand we're going to have conflicts on on certain issues. Directors come here from different backgrounds, and that is all healthy and good, and I don't want to discourage healthy debate. I just want to ensure that people don't make it personal. Board interactions with the staff sometimes comes as a surprise with new directors that, lo and behold, I don't have any authority, right? An individual director has no authority whatsoever unless the board delegates authority to an individual director. The board has authority to act as a whole, as a unit to govern the affairs of the association. And so that means you can't just walk into the administration office and give Michael directions to do this, that, and the other thing. You don't have that kind of authority. Now, having said that, it's tough to be in the general manager role because you're working for essentially a bunch of different bosses, and it's tough to say no. But the way that this works effectively is if you're a director and you need some information from the GM, channel that through the president, and the president, who's the primary interface with the general manager, can find out what the workload is, and first of all, can make a decision. Do we really need to spend the time to get this information? Is it something that's coming up for the board in the future that we're going to be talking about? Or is this just because you're curious about something, but we don't have any issues coming up regarding that? And so the president can make that decision. I'm not going to waste Michael's time on that right now. Or might say, this is really important, Michael, I need you to handle it right away. It depends. But by having one person act as the clearinghouse for that, then, a lot more, Mike could be a lot more confident in the work that needs to get done to do his job to the satisfaction of the board. It is very tough and we've had in the past where the directors go in and the GM's like, whose project do I work on first? I mean, I don't know what's what. So, yeah.
Even if it's a simple task that the committee needs help with, should wait until we go to a board meeting and ask for that help through the board. I mean,
I think you just email or call the president.
Yeah, shoot an email.
Yeah. That you would have just something informal like that, so who knows what the.
Or in your case, call me, then maybe I'll call back.
I know what you mean.
Alright.
No, that's good to know, because I don't know if we've always done that, you know. I mean, it's not like we're asking for 6 months of help or something, but just something fairly simple. We just have called our GM, but we can change that if that's a recommendation.
Yeah, I think that's the right thing to
Yeah,
do.
There
good.
was a policy that we worked on last year that says, you know, that you don't go into the office and ask stuff. You know, make a request of the president or the general manager first. And then see, you know, allow them to, you know, decide, you know, is there time for people to do this? It's kind of like before every board meeting, there's at least 3 of us, if not 4 of us, that always ask for full paper copies of stuff. But then once the agenda and the packet is set, it's up to Michael to say, hey, you know, there are these 4 people that always want these packets, see if they get made.
Out of both.
Or it's somebody's job.
How does that work with committee chairs? More direct communication, or should that all go through?
Again, I think it has to go through through the chair, because I mean, I think that the chair's got the best knowledge about what the general manager is doing, what the workload is like, what the priorities are at any given time. And so I think it's best to channel that through the chair.
So if we need the agenda packet printed, we should go to Keith asking.
Well,
No.
not for
Well,
that.
that's why I'm saying, I mean, something simple that, you know.
Yeah, my point I might make, yeah, we have a list of the directors who want theirs printed and how they want to print it, so if there's any change, just let us know. But in reference to the ACC though, there are a couple of team members who work directly with the committee in setting their agenda of architectural approvals and appeals and so forth. So I would say that would be one instance where our staff works directly with the committee.
And Diane works, Diane works directly with the N&E committee in that same way.
And that's what I'm referring to.
I think we had a document that just said for these issues, direct contact with, so that everybody knows, right? We can talk about them here, we just probably don't have anything right. Yeah. Okay. Perfect. So the chain of command is board evaluates the general manager, but then the general manager is responsible for everybody under the general manager. And you have to allow the general manager to opportunity to manage those employees. There can be a temptation for the board to get involved in managing those employees. You need to stay out of that. There needs to be a distinct chain of command that's in place. Okay, so I've talked about the request for information. Role of the president outside of board meetings. So the president is the principal contact between management and the board, has regular meetings with the general manager and helps set the agenda. You know, setting the agenda is not routine. It's like what you have to decide what issues need to come before the board now. And what should take priority for this meeting. We've got a lot of stuff to talk about. What can be deferred? Sometimes the question is, well, do we really have a decision here? Is this something that we even need to bring to the board right now? So, I mean, all those factors come into play for every meeting. And the president is instrumental in assisting with that along with the general manager. What about the general manager? Okay, so general manager is an employee, the chief officer of the association. Again, the role is to manage all employees and to be the primary interface with outside consultants. So who do I talk with at Sun Valley? I occasionally will talk to Keith, but most of the time I'm going to be talking to Michael. Because the things that Michael are going to be contacting me about are management type stuff, not government stuff. He's the primary information source to the board. He is, boots on the ground. He is the one who's going to hear complaints or accolades from the membership. He's going to hear about things oftentimes before the board does. So you are going to expect him to bring information to the board, and what you require out of your general manager is someone who's an honest broker of information. In other words, there are times where there's bad news, and there's times where there's good news, and you want the straight story on the bad news just as you want the straight story on the good news, right? You want somebody who's going to tell you what the situation is and not sugarcoat it. Or if there's an error, sometimes mistakes get made. You don't want somebody covering up, you know, you want them to be honest about things and to figure out, okay, that happened, so where do we go from here? The other challenge that general manager has is that, you know, you do have opinions of your own. And yet, at the end of the day, on these bigger decisions, the board is going to be the one that makes those decisions. So, you need to sometimes march off smartly if the decision doesn't go in the way of the recommendation of the general manager. But at least can be assured that, look, they had a fair opportunity for input, the board considered what I had to say and made an informed decision. The board or the GM, just like every director, supports the board's decisions, whatever those are, whether it was consistent with the general manager's recommendations or otherwise. Supports the culture of the board as the board has developed that, and then implements the budget. So one of the most important things you can do each year is pass the budget, because it's your chance to set your priorities in relation to everything else, all of the other demands that you have to deal with. And then the general manager is kind of the principal interface with members. And that means kind of knowing what the board wants, getting clear direction from the board, not speaking out of school. So then, just to kind of summarize what the difference is between governance and management is, if you think about kind of the bigger issues that are affecting, Sun Valley will be facing, policy decision, capital expenditures, for instance, what do we do about all of these trees that we got here in Sun Valley that tend to blow down during windstorms? I mean, do we need to have some kind of program to address this? I mean, that's a policy decision. That's a big issue. And I guarantee the membership is wondering, what are you going to do about this kind of thing? Anything that costs a lot of money, that's, you know, a bigger issue that the board is going to handle. Then once the decision is made, it's up to the general manager to implement that. So the board is thinking about those longer term issues, whereas the general manager is often thinking about, how do I get this done on a daily basis? I mean, you got to call the arborist out here to look at this tree because somebody complained it's a hazard tree. That's a day-to-day thing, right? So that's the difference there. The board in setting governance wants to provide that overall direction so that the general manager can get the job done, right? And the guarantee of the general manager wants direction, clear direction on what to do. It's one of the reasons why these board meetings are helpful, because it's information that the general manager needs to do his job. And since the board is dealing with the big picture, your decisions don't have to be hasty, unless there's an emergency or something that really does require quick action. But in general, you can take some more deliberate time. Whereas on occasion, you got a snow event overnight, Michael's got to find a way to get the snow trucks on the road, get the roads cleared. I mean, he's going to be acting much more quickly than the board. Governance strategies. I always suggest you articulate a vision of where you want to be a year from now, 5 years from now. What big items do we have that we need to start planning for? I mean, I mentioned one tonight. You got Wacoya coming down the pike in January 1, 2020. So how are you going to reach that? Do you want to start earlier than 2027? What do you want to do? That's an issue that you're going to need to talk about. Another suggestion is make one of your first meetings of the year, make a list of items that if we get these things done this year, we're going to think this is a pretty good year. We were successful. Govern through your budget, right? You took a lot of time to create your budget. That's where you focused your efforts to really set your priorities, govern through the budget. And so again, as I said before, with your budget, this is the only opportunity you have to make decisions in perspective. You know how much money is going to be coming in. Okay, we got $500,000. What are we going to do with that money? We've got all of these demands on our resources here. What are we going to say is the most, the highest priorities? All right. So really focus your time there each year. Set those broad priorities so that the general manager can manage the budget throughout the year. And you'll have things that happen you didn't anticipate. Did we anticipate a bomb fight? No, we did not. And so now we have expenses that we had not anticipated. Now the general manager has to kind of work within that. Okay. So the other thing that kind of, implementing budget-based governance does is it preserves your time. Because there will be things that happen throughout the year, that were not in the budget, right? If it's in the budget, it's presumed valid, right? We've already made that decision, so we don't really have to have much of a discussion about that. But if it's not in the budget, then we need a solid explanation. And there certainly will be things, you can't anticipate what's gonna happen 5-6 months in the future. But we need a solid explanation why we should now fund that. And what are we gonna do with the money that was allocated elsewhere? That's what I mean by budget-based governance. The last concept I want to leave with you is political capital. And whether you think about this or not, you've got a bank of political capital out there with the community. And that political capital is positive trust and confidence that members have in the board. And I'd like to call it the benefit of the doubt. So when you go to the membership and ask them for something, you ask them to approve a ballot measure, or you ask them to, approve your budget. It's easy to do under Latoya, but still, I mean, you want the membership to approve your budget. You want them to approve amendments to your governing documents. Well, if they have trust and confidence in the board, that this is not some underhanded thing, some nefarious action, they're going to approve that. But if they think the board doesn't have a lot of trust, if they've been holding secret meetings and things like that, then they're less likely to give you that benefit of the doubt and to scrutinize whatever it is you're asking them to do. So how do you make deposits in that bank? Because it's really important to build that bank up. Well, run your meetings well. If I'm a member and I turn into a meeting and I see that you're having a good, healthy discussion, I'm gonna say, well, things are going well. I like what the board is doing here. So run your meetings well. No scandals, right? Sexual harassment claims and things of that nature are not good in building trust. Have an appropriate culture. Done that by adopting a code of conduct, abiding by that. That's a great start. Outreach into the community. I mean, you do need to have contact with the community. You can't be aloof. This is this is kind of an active job, and you're the leaders of the community. So don't, you need to be out there. You can forfeit what's in your bank account by doing things like making dumb decisions. And what I mean by that is not something that's unpopular, because you will need to make unpopular decisions from time to time, because you have more information than the membership. So you're going to need to sometimes take the heat from the membership who doesn't understand an issue fully, because you know that it's the best thing for the association. It's not what I'm talking about. I'm talking about a decision that wasn't well thought out, it's just kind of stupid. Those that, that kind of withdraws your capital. Or you don't run your meetings well, or your, membership knows that meetings are being held offline and they're not getting to see those. Or, there's a lot of chatter on social. I think that really can be a forfeiture from your bank account, is when you've got directors just talking frequently on social media. And as confidentiality leaks too. I mean, if I'm a member and I'm thinking, well, how am I getting this confidential information? That's not good. Something's wrong about that board. So I think all those things can be forfeitures. So then, how do you use this political bank account? Well, you make withdrawals from it. Just like you had money in your account, it's to the good of the order. You get trust in the membership when you come to them with a special assessment request or to support a ballot measure. That's how you can withdraw that political capital. So keep that concept in mind as you serve here on the board. And with that, I've concluded my presentation. And if there are any questions, happy to answer.
Thank you, Richard. Do we have any questions? Everything, Richard, any additional questions? All right, hearing none. Richard, thank you very much for your time. I really appreciate you coming down tonight and keeping us forever.
Thanks, Richard.
All right, at this time, Spencer, we're going to take a 5-minute recess. Okay,
Yes, we can.
We're gonna make a-
Let me get there, because you're gonna say,
I know.
my little look at time. Okay, go for it.
Because we can take, Greg, we got time in between, so we'll take a little 5-minute recess, at the meeting, 7:36. Recess. Move back to All right, we're gonna call our meeting back to order at 7:45 PM. And do we have Andrew Rutherford with Hub International Insurance on joining us via Zoom for the insurance portion of our orientation?
Hi, hello. Can you hear me okay?
Introduce him.
Yes, good evening, Andrew. Can you hear us, okay?
I can just well. I can go ahead and share my screen unless everyone has copies of what I'm mentioning.
Excellent.
Yep, perfect. Go right ahead.
All right, let's.
Oh, Lori's, she says when we went to break, she was cut off when recording stopped.
I'm back now.
Oh,
Okay,
she's back.
okay, all right.
Perfect.
The insurance guy, Lori, is gonna be doing screen sharing.
Yeah, I can see a screen now.
Okay.
Thank you.
Yeah, hi. I apologize. I couldn't be there in person. I have a 5.5-year-old who, you know, getting near bedtime. So here we are.
No worries.
All right. So this is a pretty general overview, and please feel free to stop me, ask any questions at any time, or if there's any questions afterwards, I'm happy to answer them. But I kind of keep it pretty simplistic in terms of general what's covered, what's not, what limits do you have, and then we can dive in any further with any questions.
All right, thank you.
So overall, all of your property is on what's called a blanket property policy, which means we have a total limit for all the buildings owned by the association of $13,034,042. They're rated on replacement costs, which means if there was to be a fire or some other kind of loss, the insurance carrier would cover that building per structure up to that limit, up to the cost to replace it. So there's a chance that, you know, that limit may look a little low if you add up everything, but if you look at the probability of everything put together and having an occurrence at the same time, it's probably not likely. With that said, within that property insurance policy, there's what's known as business income extra expense. So that would cover any kind of costs associated outside of the buildings themselves and the contents within them to get you up and running like new. So what does that mean? That means, you know, if there's a temporary structure needed, does it need to go somewhere else? If there's any wages that need to be paid, anything that's not considered part of the property policy. So, you know, building itself, contents within, items within that, it would cover insurance up to that limit outside of that. The other piece of that property policy I want to mention is we have building ordinance of law coverage, which is an extra $500,000 of coverage that would cover anything that would have to be rebuilt up to current code. So what that means is your current policy covers replacement costs, replacement of that building as is. If there's anything outside of that, like easy example to give is, you know, if there's sprinklers required or an elevator for ADD complaints that are grandfathered, you have up to $500,000 of additional insurance to get that building up to current codes if there was to be a loss. We do want to note that all property insurance policies do exclude earthquake and flood, because that coverage can be purchased outside of that. The next piece of coverage we have is what's called inland marine. Go ahead.
All right, so you just said does not cover flood and earthquake?
Correct.
Correct. On commercial insurance policies, that's a separate coverage outside of that you guys do not currently have coverage for.
Okay, thank you.
And it's something we could always look at, you know, if there's any, you know, maybe not necessarily on every building or structure, but if there's any that you would want to look into that coverage, we could do that for you. No problem.
Thank you.
The next piece of that policy is called inland marine. Even though the word marine is in the description, it doesn't necessarily always mean marine items. It's just a term in the insurance industry. But in this case, it does cover your marina bulkheads and docks with a $1.5 million limit. Unlike the property, that policy is covered on actual cash value, which essentially means it's the depreciated value of that item. So what that means is if you had a loss, like we mentioned before, obviously probably wouldn't be a fire if it's on water, but another kind of loss, they would replace that of like kind and quality of what the existing piece is. And also on that policy, we have coverage for the greens on the golf course, as well up to $200,000 of coverage.
Can I ask a quick question? So is the dock only covered if they basically just sank, not sinking as a result of wind or waves? They just sunk?
It would be, yes, correct. And it would also be covered, the easiest way to think of it when we're talking property coverage, which would be your inland marine and property, would be, is there property damage to that, right? Say someone ran into it with something, anything that would damage it caused by someone else. So what that means is, you know, wear and tear is not covered, right? Unless there's something that caused that. Easy example would be that I kind of use as a parallel, not the same thing, but you know, your personal auto, right? If someone was to have their auto break down because they didn't do regular maintenance, oil change, things of that sort, that wouldn't be covered in your insurance. But if someone hit it with a baseball bat or got into a car accident or a tree fell on it, you know, it'd be covered for those items.
So question for you, so if let's say one of the boats that's in one of the slips has a fire and part of the docks are damaged by that, that would be covered, but wind and wave are considered acts of God?
Correct. Yes. I mean, there's some more nuance to that. And what I mean is there's an argument sometimes you can make. It's not as cut and dry, right? And I mean cut and dry to your benefit. It does say wind and wave is excluded, but often what they're meaning by that is, you know, a high windstorm or wave caused by like an earthquake or event of that sort. But you were correct that if it was a fire, it would absolutely be covered.
Yeah, it's just, we went through that bomb cyclone out here and thank goodness, nothing really bad happened to most of
Right.
the assets.
Right.
It protected us.
Yeah.
And what I guess I should say that I didn't right away off the top is, you know, if there's ever any kind of damage or potential insurance claim, look, I'm your advocate. I'm not the insurance company. I'm the broker, right? So you can absolutely call, or the board can call, or whoever, you know, is the point person could call me and have a discussion. And just because you talk with me doesn't mean I'm going to talk to the insurance carrier, right? We could run through if we think it's going to be covered or not. You don't necessarily need to make those determinations on your own.
Okay, thank you.
The next piece of coverage that we have is crime coverage. So employee dishonesty, forgery, or alteration. So basically, you know, if anyone stole anything from the association, if anyone wrote bad checks from the association to themselves, anything crime related would be covered under that policy, with the caveat of you do have a cyber insurance policy. So if there was a cyber crime of some sort, you know, that would be covered elsewhere up to $1 million. And then kind of switching gears from property itself, we have general liability coverage. So what's a general liability claim? It would be bodily injury of anyone on the premises or any kind of liability claim caused by someone on the premises. You have $1 million occurrence limit, the $2 million aggregate, but we also have an umbrella, which we will get to later on, that sits on top of that, giving you much higher limits of coverage. And that could range from anywhere, claim example wise, you know, a slip and fall to, I don't know, I'm trying to think of scenarios. Someone's working on the golf course and, you know, causes an injury of some sort to someone who's not an employee, that would fall under workers' comp. That would also be covered under that policy. Additionally, we have commercial auto policies for the owned autos. Like the general liability, it has $1 million limit with the umbrella that sits on top of that. It also has coverage for if a motorist was to hit your vehicle with not the proper insurance amount, up to $1 million, or if they didn't have insurance, your insurance would cover it. Additionally, if the board or an employee was to use their own personal auto for any reason through their course of business, and there was a claim and somehow, you know, the claim got pushed to the board or the association, this policy would also respond to protect the association. And then, like I mentioned previously, we have a $15 million umbrella limit. So that sits on top of your general liability and your auto liability. So essentially, the easiest way to think about it is you have $16 million of coverage for auto and general liability. And it also sits on top of your directors and officers coverage, which we're about to get to. Regarding the course, we also have pollution liability for the course of $1 million limit. And again, this would be, you know, anything that could be deemed a pollution claim. So this could be anywhere from, you know, depending on the type of pesticides that got into the water, or diesel leak or gasoline or things of that sort. And then the piece that's probably most important that would be to me if I was on the board is the directors and officers coverage. That's also in conjunction with employment practices. So first I'll talk about directors and officers. Directors and officers basically means anyone who takes a volunteer position on the board is covered. Kind of going back, I didn't hear all of the meeting, but prior they were talking about, you know, making decisions that other people may not agree with. If for some reason someone decides to file a suit for that type of item, you have insurance coverage to cover that. And again, the umbrella goes over that. So we have $16 million of coverage for that if anyone was ever to file suit or anything to protect the board themselves. The other piece of that policy also is employment practices, which means, you know, anyone employed by the association, if they were to harass someone, feel like they're being discriminated against, claim they have wrongful wages, there's also insurance coverage for those types of suits as well. And that can also be, I do want to mention on the employment practice, that can also be third party, which means, you know, if an outside person was on the premises and says an employee did something to them, you also have coverage to protect yourself for that as well. Is there any questions on the directors and officers employment practices or anything else I mentioned
I
at
think
this point?
I have one question for you. So if we have a subcontractor that works for us and somehow they're involved with something that deals with the association, do we have coverage or they have their own coverage under their contractual obligation to us?
So the quick answer without having, you know, a specific example is both parties have coverage.
All right.
And I, you know, I don't want to go too far down this rabbit hole, but I would say any contractor you hire, make sure they add you as an additional insured under their insurance policy, which basically is making their coverage primary and your coverage secondary, right? So you want their coverage to be responsible for anything they cause first, and then your coverage is there in case they don't have the adequate coverage.
Okay, thank you. I get what you're saying.
Absolutely. Yep. And you know, if there's ever a contractor you're hiring, and again, any questions on that stuff, it can get kind of nuanced. Myself or Mona is happy to review that for you and discuss that with you as well. Because it's kind of hard, right, when you start picking hypotheticals until they come up.
Yep, thank you.
And that's kind of like the basis of your insurance overall. Like I said, I kind of kept it pretty broad in terms of coverage and amounts. The next portion of this is kind of examples of some of these items that I probably alluded to in my description, but I will go into a little more detail. Directors and officer coverage covers wrongful acts, right? I mentioned errors, misstatements, omissions, breach of duty or employment. Who's covered? Basically the entity and all the board and anyone employed. And what would be paid? Damage, settlements, judgments, defense costs. And again, kind of like what I said, what could be covered potentially under that is salaries, overhead, punitive damages, taxes. Basically, you're thinking of it as this insurance policy is, you know, essentially going to cover you in defense of anything that anyone would allege against you.
Quick question, are members of the ad hoc committee who are not board members, are they covered as members of those ad hoc committees?
I believe so. The reason why I'm not going to say 100% yes is I'm 99.9% sure, but I would like to refer to your policy and get back to you on that. What was the committee? What committee was it?
Well, my case would be the members of the Nominations and Elections Committee, or it could be the Architectural Control Committee, Safety Committee.
Yes, so
committees.
They are covered. And I remember I had this conversation last year, so I know they are covered under this policy. Anyone acting on behalf of the association is covered under this policy, as long as it's within their responsibilities of that committee or the association.
Thank you.
So like why I say it that way is, right, if there's a rogue homeowner, right, who wants to make decisions on their own, your insurance isn't automatically extended to them because they're not supposed to be making those decisions.
Andrew, this is Michael Bennett, the general manager. There was a question raised by one of our directors concerning event insurance for special events sponsored by Sudden Valley. And I think your answer coming back from Liberty Mutual was, as a guideline, they don't want to see special events on the property that invite the public in general. There's likely, it's saying likely protection for events on site limited to members, but can you elaborate on that for the board?
I can. So long story short, if there was ever a occurrence, the liability would cover that. But it's not as broad as it would be as if you were to purchase a special events coverage. And just to give you an idea, depending on what the event is, they're usually $100 to $200 for event coverage. So what I would say, if it's going to be a big event, we should probably place coverage outside of that. But your carrier will have to defend any kind of liability that happens on the premises, if they like it or not, basically. It's the easiest way to explain it. They can say they don't like it, but if there's a liability and they're your insurance carrier, they have to cover it.
Thank you. Thank you.
One
And I don't know if I answered that well, but I'm happy to elaborate.
Just one question, and I'll give you a specific event. We do a rather large holiday fair, craft fair, where we have crafters that are from our community, but we also have outside crafters. Are we just covered by most of it's in the dance barn? And they pay a fee, they set up, it's just for one day.
What's your question?
Would our insurance cover, or would we need something special for that?
Your insurance would cover you from any liability. I guess what I would ask, the question I have back on that is, are you selling any kind of alcohol or anything that could be
No,
potentially outside of the
no,
scope?
just
I mean, if you're
craft.
charging a cover and handing out alcohol, that's fine, right? But like if you were to sell those kind of items, I would say we absolutely should place an outside policy. But if it's nothing out of the ordinary, your liability would pick up anything that would happen at that.
Okay, thank you.
But that's not to say you.
The answer to the question that we provided was from the underwriter at Liberty. So to take it a step further, what they're trying to do basically is like, we don't know a specific example, so we don't want to, say an absolute yes, right? That was kind of the tone of that answer that was coming from that underwriter.
Gotcha.
And again, anything out of the ordinary, happy to discuss in detail as those come up. But if anything was ever to happen off the premises by the association, we would need one of those policies. And like the example I would give is like, I have a lot of clients, that are like a manufacturer or a business that would have a company picnic. Since it's not on their premises, their liability is not following them. So if there's anything that's off the premises, it'd probably be best practice to get one of those policies.
Gotcha.
Again, further on, I'm sorry, if there's any more questions, please go ahead, or I can continue on.
Yeah, continue on.
Okay, so continuing on directors and officers coverage, claims definition is typically first, but it's important to note on the directors and officers and employment practices, unlike your property and general liability policy, if there's anything of first notice, so an example of that could be, a letter from an attorney, or employment practice would be like an EEOC complaint. Definitely give us a call or reach out right away, because this policy does want notification immediately versus your property or general liability don't necessarily require that. And the reason why that is that way for multiple reasons. One is that the carrier doesn't want to basically see you go down the road of trying to hire your own attorney and take it far and then have to step in after it's already been started. They want to do that at the beginning of these things. And it's kind of nuanced, as I keep probably saying a little too much, but if any kind of those complaints, lawsuits, EEOC complaints, let us know, let's have a conversation, and let's determine the best route.
Okay.
Examples of exclusions to this policy would be bodily injury, because that would be covered under your property policy. And then any criminal acts, it does say dishonest, but that could be covered depending on what it was. Criminal acts that are caused intentionally potentially could be excluded as well.
Colonel X.
And then well, I'm trying to think of the example that would best define it, but essentially what those exclusions are alluding to is if it's covered elsewhere under your policy, they're not going to pick it up. So bodily injury, criminal act, employee dishonesty, right? That's covered under your crime policy. So your directors and officers, employment practices wouldn't cover that because you have coverage elsewhere. And then examples of common claims, which we've kind of talked through a little bit, but like a challenge to the board authority, someone's mad about an assessment, defamation, discrimination, breach of contract. Those are typically the main claims we see that fall under this policy.
Andrew, Michael Bennett again, can you clarify, in the case of an exclusion, intentional torts on behalf of, say, a director or a volunteer?
I'm not 100% sure what you're asking. Can you say that in a different way?
Sure. Most D&O coverage excludes intentional torts, intentional wrongdoing on behalf of a officer or a volunteer.
Yeah, they would cover it from a lawsuit standpoint, but they're not going to maybe necessarily fix the thing done. And again, we're getting into the area of like, you know, it's hard to kind of go through this until there's an actual claim. But if there's ever any kind of like lawsuit or criminal act, this policy will typically cover it.
Indemnification versus paying for the judgment. So you
correct. Like if they do find in fact, if court ends up finding in fact that the board is responsible for the claim, if there's damages, the carrier is not going to necessarily pay those damages, but they're going to pay the defense of it.
Right, going to pay the defense. Okay, and then the last one I have is on what do you prefer on tendering notice of claim? What do you consider? We want to minimize the cost of tendering notice of a claim to the carrier if it's not going to result in a claim, but we want to make sure that we follow our legal obligation on claims made or on occurrence. So what is your recommendation?
Absolutely. Kind of what I said before is I think we should always have a discussion about it as your advocate, right? We work for you. Yes, we're partners with the insurance carrier, but we're your partner. We do have internal claims people at our company hub that can advise on those items if I feel I cannot. And they've all been licensed adjusters for years. So I think kind of the best route for any of those things would just be to have a conversation about it. I mean, look, if it's something that someone's alleging property damage, it's minimal, they want a small amount of money. Yeah, we don't need to turn that in. But anything that would be potential lawsuit, I think it's definitely worth the discussion to have, at least internally between us and you guys, not necessarily with the insurance carrier.
Thank you.
I have a question for you. We never see this
Yeah.
on stuff you give us, but what is our deductible as far as any of our claims go?
I can tell you that. Hold on a second. And I can provide that actually after this if you'd like.
I always ask because I'm assuming it changes all the time.
I don't think it's changed recently. And by recently, I mean in the last couple of years, but it's definitely something to know, right?
Yeah.
Let's see here. Got a couple of things here. So for the property coverage, the deductible is $5,000. For the general liability, it is $500 for physical damage. For liability, there's no deductible. And then the higher deductible, I believe, is on the directors and officers. So I will get you that exact number. Yes, the deductible for the directors and officers in employment practice is $25,000.
Okay.
Which I know sounds high.
You just gotta really do something wrong.
Yeah, I mean, that's kind of the idea, right? It's got to be a big issue. and typically when they get to that point, they are. And what I was gonna say is, it used to be $1,000 deductible on this, used to be 5,000, and when I say used to, I mean 10, 15 years ago. But it's kind of the industry standard has bumped it up to these $25,000 deductibles, just because of where they're seeing these things go.
Yeah.
The costs are much higher than they once were.
Absolutely. Okay, thank you.
Yep, and I'm just looking one last thing before I tell you. The fiduciary has no deductible, and yes, employment practices is 25,000 as well.
You have any additional?
That's pretty much all I have.
Andrew?
But I'm open to any questions.
No? All right, Andrew, looking like, that's it. Looks like we don't have any further questions from you, man.
You put the 5-year-old to bed now, but don't forget the bedtime story.
Yeah.
Unfortunately, I've put myself in a hole of having to read 3 every night. As he gets older, they get longer.
Yeah.
But as much as I complain about it, it's probably one of the best times of night.
Yeah, it is.
They act much younger than they are when they're sweet like that. So what are you gonna do? Any follow-up questions? Please do not hesitate to reach out. I know Michael has my information to myself or Mona. I apologize I wasn't able to answer one of the questions is regarding employee benefits. I know Jason's out of town till next week, but he will absolutely get back to you guys too on that as well.
Thank you.
Thank you.
Absolutely.
Very
Have a
much.
good night.
Thank you, Andrew.
Bye. Thank you. Bye.
All right, Spencer, at this time, we're gonna take another quick recess in just a few minutes before we start with our parliamentarian at 8:15. So we got like 4 minutes. Recess at, it's 8:12 now. Take a quick
5
recess
minutes,
at
8:12.
Yeah, so we got a few minutes stretch, get some water, whatever you need to do, and then we'll start on our.
Well, it'll get cold. Oh, that can be go.
We're gonna call our meeting back to order at 8:18 p.m.
All right.
8:18 p.m. We are gonna proceed with our parliamentarian, Paul McClintock. He's gonna do the next part of our orientation
can't
meeting
read.
tonight. And Michael, I'd like to introduce Paul.
Hi, Paul, can you hear us okay?
I can you hear me?
Yes, 5 by 5, sir. I'm Michael Bennett, of course, our board of directors here, and we can have make you one of the hosts and presenters so you can share your screen.
Very good.
There
Let's
you
see.
are.
There we go. Well, we've got it, and you can start your presentation in PowerPoint at your end.
Okay, does that come out on full screen on your screen there?
Yes.
Yes, it does.
All right, good. Well, thank you for having me. I have served as your annual meeting parliamentarian a couple of times, and I will present a three-part presentation. I believe it's about 30 minutes allowed for this. The role of an annual meeting parliamentarian, some best practice tips for board meetings with respect to parliamentary procedure, and then any questions and answers you may have. So to go right into the annual meeting parliamentarian, you have various governing documents, as you know, your bylaws, and in Article 2, the part about meetings and quorum and voting says that the president or his or her designee shall preside over all meetings of the association. So the president can designate a parliamentarian to preside, or the president can preside. In the absence of the president, the vice president, of course, would preside normally. Or again, I think you would say perhaps that they could have a designated person if the president were absent. So the secretary shall keep the minutes of the meetings and record in the minute book all the resolutions adopted at the meetings, as well as a record of all transactions occurring during the meeting. Now, these are some things that are in your bylaws, but just to give a little bit more context to it than that, your last statement here on this page is that Robert's Rules of Order shall govern, and it has a few more things about what goes into the minutes. It's not just those that are adopted, but any resolutions that are proposed, and if they're defeated, they would also go in the minutes and be noted as having been defeated or lost. So the statement here about parliamentarian is also in your bylaws. So your bylaws require having a parliamentarian that's not a member of the association present at any meetings of the association where a vote of the membership may be taken. So that's not a requirement in all organizations, but there are plenty of organizations that choose to have a parliamentarian even if it's not required. So
You say member of the association, are you talking a lot owner?
Where members are gonna vote, Rob, so meaning generally the annual general meeting.
Is the only one they vote at.
Yeah.
so in terms of not being a member, that means that one of your lot owners cannot be the parliamentarian that this is talking about. You need to have someone serve as your parliamentarian who is not a lot owner.
Third party. Thank you.
Okay, and so let's talk about that for just a moment. To be a lawyer or an attorney, you have to be licensed to practice law. Parliamentarians are not licensed. So you're not going to find a licensed parliamentarian to serve you, because license means it's the government that gives that license, that permission. And you have hoops to go through to get those licenses. Now, in the case of parliamentarians, anyone can be an expert on Robert's Rules of Order and on your rules, and could serve you quite well, perhaps. As a parliamentarian with no credentials whatsoever. There are credentials that a parliamentarian may have. They're just not in the form of a license. So there are two national or international organizations that actually provide credentials for parliamentarians. The largest of the groups is the National Association of Parliamentarians, and it has between 4,000 and 5,000 members worldwide, mostly in the U.S., and it has various levels of membership, which correspond to different levels of credentialing. You have to pass a basic knowledge test of Robert's Rules of Order to become a member, plus pay dues. They have a second level beyond just basic membership, and it's called a registered parliamentarian, and that includes or involves passing a test that covers all of Robert's Rules of Order. So it's not just a basic knowledge, it's a more thorough knowledge. And then there's the professional registered parliamentarian level, which is what I am. And that includes demonstrating ability to preside, to serve as a parliamentarian for someone else presiding, to write parliamentary opinions, sort of like legal opinions, and so forth. So, and to evaluate in a reasonable manner how to resolve parliamentary questions or dilemmas. So the professional parliamentarian is as a credential with the National Association of Parliamentarians, we use the initials PRP, Professional Registered Parliamentarian. There is another organization called the American Institute of Parliamentarians. They focus primarily on Robert's Rules of Order, but they also have their own book of rules called the American Institute of Parliamentarians Standard Code of Parliamentary Procedure. And so they also test people for it. And someone that gets a credential there will be a certified parliamentarian, or a CP, or a certified professional parliamentarian, a CPP. And so finding someone that's an RP, PRP, CP, or CPP it gets you someone who has demonstrated to other parliamentarians a level of proficiency that it gives you more confidence that you're getting good advice. But if you happen to have someone that doesn't have any of those credentials but knows their material, at one point, let's go back to Robert's Rules of Order, which is what your organization, your association uses. It was originally written by Henry Martin Robert in, I think it was 1876. His grandson fairly recently passed away, and was one of the authors on an authorship team of about 4 to 6 people. And before he passed away, there was a point in time, maybe 10, 15 years ago, when he was not credentialed by either of these organizations, but he certainly knew the material. And so he actually served as parliamentarian for various organizations. And he, this is Henry Martin Robert III, the grandson of the original author. That's one example of how you might be very well qualified, but without any of the credentials. At any rate, it's not a requirement in your rules that the parliamentarian be credentialed. Okay. Speaking though of what Robert's rules being adopted, we're going to look at some of the provisions in Robert's rules, and particularly concerning what a parliamentarian's job is. So you want to know what a parliamentarian does for you at your annual meeting. Well, the parliamentarian is a consultant who advises the president primarily, but other officers, committees, and members on matters of parliamentary procedure. And the parliamentarian's role during a meeting is purely an advisory and consultative one, since the parliamentary law gives to the chair alone the power to rule on questions of order or answer parliamentary inquiries. So if someone is wanting to know if something's in order or not, it is the chair's opinion that matters. And the chair, if the chair has questions, can whisper to the parliamentarian, what should we do here? Then the parliamentarian can advise, and the chair is then free to, perhaps knowing more than the parliamentarian does about something that's relevant, can decide that, oh, I don't have time to really explain what I know differently than the parliamentarian, but with this other bit of knowledge I have, I think that the situation here really involves me doing something different than the parliamentarian advised. And they can do that. They can, without even explaining it to anyone, make a ruling or a answer to a parliamentary inquiry that is contrary to what the parliamentarian suggests. It is their prerogative to decide how to rule on questions of order. So parliamentarians give advice, and the chair makes the rulings. So here are some additional comments. A small organization should rarely require the services of a parliamentarian unless it's to undertake a general revision of its bylaws. But for large assemblies and conventions of organizations where the transaction of business is apt to be complex, it's advisable to engage one. Some state or national organizations find it advisable to employ a parliamentarian throughout the year to assist interpreting bylaws and rules, or helping boards and officers or committees. Sometimes there's formal written opinions that are given, and sometimes giving opinions just at the meeting to the presiding officer. I will say that in my experience, most of my clients are either homeowner associations such as yourself, where it's for the purpose of an annual meeting. Occasionally, I'm asked, like tonight, to give some training to the board. I had one board that hired me to do some training because they had the board had been conducting business so poorly, in a sense, that they had lawsuits they had lost. They had a property management company that had said, when our contract's over, we're not renewing. And they had insurance that you just heard from your insurance guy. Their insurance company said, we're dropping you as soon as we can. And their agent who had gotten them that insurance company said, I'm not going to be able to get you another insurance company unless you get some training on how to run meetings properly. And that's why they hired me. So I think you're in a lot better shape than this other company was, this other homeowner association or condo association. But I did meet with that board a few times after the training as well, just to observe and give further feedback. Typically, though, it's a state or national, sometimes international organization that will hire me for the reason that they don't want to find out after a big expensive meeting that they did something wrong that could have been avoided by knowing the rules. So it's just too inconvenient to have a special meeting to meet back together to fix some mistake they made. And so it's worth spending money on a professional parliamentarian to help avoid those problems. All right. Appointment of the parliamentarian. President should be free to appoint one in whom he has confidence. The board or society must approve any fee that will be required, however. And if needed for only one meeting, a parliamentarian should be appointed as far as possible in advance so that they can prepare properly. The duties of the parliamentarian. Once the president knows what the business is, they should confer with the parliamentarian. And again, during recesses, in order to anticipate any problems that might arise, what can be avoided, be prepared with wording or scripting for how to process unusual motions and so forth. There's no set rule for the number of additional functions a parliamentarian may be asked to perform. I've been asked to give a little quick overview of Robert's Rules of Order to the Assembly at the beginning of a convention. I've been, or as a separate event at a multi-day convention. So I've also taught. I do a lot of teaching classes on Robert's Rules and so forth. So most of the interactions with a homeowner association is typically by email and on the phone, consulting in advance of a meeting, sometimes in between meetings. I have an attorney that consults with me periodically about his clients, which are generally homeowner associations. Those are the kinds of things a parliamentarian might be doing. During the meeting, the parliamentarian should be just giving advice to the chair, and when requested, to other members, but it's generally, if that's avoidable, if it can be done through the chair, it's preferable. It's also the duty of the parliamentarian, as inconspicuously as possible, to call the attention of the chair to any error in the proceedings that may affect the substantive rights of any member or may otherwise do harm to this organization. For those reasons, the parliamentarian should be seated close to the presiding officer during the course of the meeting, so the parliamentarian can whisper or otherwise gain the attention of the presiding officer. Presiding officer may need to simply say, the meeting will stand at ease while the chair consults with the parliamentarian. There should be an understanding between the parliamentarian and the presiding officer that there will be probably occasions when it's essential for the chair to listen to suggestions from the parliamentarian and may ask the assembly to stand at ease during the consultation. This practice will enable the chair to be in a position to act promptly at the correct time and be fully informed. In advising the chair, the parliamentarian should not wait until asked for advice. That may be too late. An experienced parliamentarian will often see a problem developing and be able to head it off with a few words to the chair. Sometimes that's done verbally and sometimes with written notes. Only on the most involved matters should the parliamentarian actually be called upon to speak to the assembly, and the practice should be avoided if possible. The parliamentarian should be assigned a seat next to the chair, and they should not be constantly checking with each other if possible. If necessary, if it's something that's involving constant checking, it probably is time to simply ask the parliamentarian to preside over the meeting. The last paragraph here is the parliamentarian has, after the parliamentarian has expressed an opinion, the chair has the duty to make the final ruling, and in doing so has the right to follow the advice of the parliamentarian or to disregard it. But if a parliamentarian's advice is habitually disregarded, he may find it necessary and appropriate at the end of the present engagement to resign and not continue serving that organization, or at least that presiding officer. Let's see, here we go. A member of an assembly who acts as its parliamentarian is covered in Robert's Rules of Order. Has, I guess you'd call it Chapter 47 and Paragraph 55, and they note the reference with the colon there. And since your situation does not allow a member of your body to be the parliamentarian that's required, I didn't put the details of that there, but you can look it up if you have the interest and need. Similarly, you don't, your annual meeting is not a convention. A convention, as that last statement says, is a convention of delegates, lower level subgroups that elect a portion of their number to be delegates. They delegate to them the power to represent their subgroup at the upper level meeting called a convention. An annual meeting is what you have, and that's where all the members get to attend and vote, not just a subset. So the rules in 47:56 don't really apply in your case either, but there's some additional matter in Roberts on those subjects. All right, with that, let's see. Let's take a look at your bylaws again. It says your parliamentarian serves as the meeting parliamentarian at the annual general meeting in November in Bylaw 2, Part 8. And this includes reviewing governing documents and the meeting documents, such as the call to the meeting, any notices that are included with that, the format of the ballot or the proxy form, and things of that nature. It includes advising the association before, during, and after the meeting. It should include consulting in advance of prior to you actually sending the meeting notice out, so that the parliamentarian can ensure that the proper notice is given. That's one of the problems that can be very irritating, is you think you're doing everything right, but you send out the notice, and which has to be so many days beforehand, and after that deadline has occurred, yes, you sent the notice out, but you find that you didn't get something quite right, and that becomes a problem. So it's good to have a review of that by the parliamentarian before it's sent. The Nominations and Election Committee Manual says the staff will contact a parliamentarian to schedule their attendance at any election, and this should be coordinated with the board secretary. So that gives you some of the rules that you have in your rules concerning your annual meeting parliamentarian. Are there any questions on that part before we get into board meetings?
I've got one question for you.
Uh-huh.
I'm the board secretary, so I normally do the minutes. If you are consulted, or if, I know if somebody raises a point of order, those have to be recorded. But if you rule or express an opinion on something else, does that have to be recorded or not necessarily, if it doesn't involve a vote? If it's just maybe a member is not conducting themselves well or something, and you step in rather than the president?
I'm not entirely sure I follow exactly what your question is, but I'll make a couple of comments and then you can clarify. So Robert's Rules of Order says that all points of order and the ruling of the chair in that regard should be recorded in the minutes. Quite frankly, I was at a meeting not long ago, about a month ago, at which there were so many points of order. It would have been, and they were not properly recognized by the chair. And there was no way the secretary could have gotten it all. But in a normal meeting, the number of points of order should be relatively small, and all points of order and how the chair rules. And after a chair rules on a point of order, someone might appeal the ruling of the chair, someone seconds it, and there's a vote, and by majority vote that can be changed, the ruling, if you will, can be changed to whatever the assembly decides. So that, of course, would go into the minutes. And those rulings of the chair or decisions of an appeal, vote on appeal, become precedents or precedents for later decisions on what should be done. So that's why it's supposed to go into the minutes. Now, as for you said something else that made me question whether that was the question you the one I just answered may not have been the question you had. So did you have something else?
No, what I was asking is if you take an action, and what you're telling me is if you discuss something, ultimately, if there's a point of order, what's written down is the decision from the chair, because that's what's legally binding.
Yes, it's the ruling of the chair that matters.
Yeah. I wrote that down. Thank you.
Yeah.
I have a question to that a little further, Paul. Then, so can any board member call point of order?
Any member in the audience can. If we've got an audience of
Can you?
500 people, okay.
Thank you.
When you're at a board meeting, only board members can make a point of order. At the AGM, any member can make a point of order.
Okay, so at board meetings, only the board can make point of order. Okay.
Right.
Very good. Thank you.
Is that because the board meeting is a meeting of business for the board of directors, and the AGM is a meeting of business for the entire organization, the HOA? Is that why?
Yes. Think of it this way. Those are two different, I'll use the word body. The body of the membership is made up of all the people that can vote those that attend the meeting. Okay, so the voting body of the membership meeting is the members. And so if you have a right to vote at the meeting, you have a right to make a point of order. I'll just put it that way.
Makes sense. Thank you.
Okay. So let's talk about board meeting best practices. As board members, you need to know your governing documents. There may be some federal laws that are involved. The Fair Housing Act, American with Disabilities Act may have a bearing. There may be others. There's state law that you have to consider. The homeowner community association law, the nonprofit corporation law, and even the nonprofit corporation law at the federal level for a 501c3 may be applicable in your case. So association amendable documents in contrast to the laws, which you don't get to at least directly amend, but you can amend your articles of incorporation, your covenants, your bylaws, your board resolutions, your rules and regulations, and your policies, such as your document called policies, your ACC, your nominations and elections manual. all those that you get to either as a membership vote or a board vote can make changes to. And then beneath all of, and this is in order of priority. So if there's a conflict between different ones of these, it's the higher level one that you have to follow. And I'll give an example in just a second. The last item here is Robert's Rules of Order newly revised. The latest edition is the 12th edition. Now, in addition to these things, you might have some meeting rules. So, for instance, at your annual meeting, you can adopt a rule that speeches and debate will be limited to 5 minutes or 3 minutes or 2 minutes, whatever you the assembly decides to go with. But if you didn't adopt a special rule like that, then the Robert's Rules allows speeches and debate to be 10 minutes. But so your meeting specific rules would be a higher priority than Robert's Rules. Robert's Rules are in a category called Rules of Order, and a 5-minute debate speech rule would be called a special rule of order, and it would have a higher priority. So, any questions on what's on the screen right there? Okay. So, annual planning. You've got your first Saturday of November for your annual meeting per your bylaws. And the bylaws say that the board sets the location and agenda, and the secretary sends out the notice and with the agenda. Then you have to have right after that, or within 10 days of that, you have to have your first board meeting with whoever is newly elected at the AGM, along with any continuing term people. And that organizational board meeting elects the officers for the year. And then it can do other business too, but it has to, that's the organizing part of it. You have your regular board meetings at least quarterly. And so that organizational board meeting can decide, okay, we have a new board, we might have a new day of the month that we want to meet. And it makes that decision. When is it we're going to have our regular meetings? How often? Are we going to have a monthly or quarterly or what? Then you have your budget calendar. The board has to adopt the budget. Within 30 days thereafter, you have to give a 14 to 50 day notice to the membership for a meeting at which to ratify the budget. And then the membership meeting votes to ratify the budget. And if I'm recalling correctly, if there's not a majority of all the members voting against ratification, then it is ratified, and you don't even have to have a quorum for this meeting. So the next item is nominations and election calendar. I'm sorry, I had to look at my printed copy because on my screen I have a sharing overlay. You are sharing your screen and a stop share button, and I couldn't see what it said. So anyway, nomination and election calendar. You have the process for that spelled out in your nomination election manual and in your bylaws. So those are just things that if you're a new board member, I don't recall if you have new board members right now or not, but those are especially helpful for new board members to get an overview of some of that. All right, so I'm going to go over some things from Robert's Rules that may help you at your board meeting. And the first is there is a standard order of business that Roberts prescribes for your board members, for your board meetings. And there's 6 steps here. Mrs. Sun is a easy to remember, a helpful way to remember them. the minutes, reports, special committees for the MRS, and special orders, unfinished business, and general orders, and new business. So let me explain, let's see what type of time. Actually, I'm already out of time. I have a couple more slides. If I'll come back, if you have any questions on this, you can ask them. There's a little sample presiding script. The meeting will come to order. The minutes have been distributed. Are there corrections? If there's no further corrections, the minutes are approved as distributed. May we have the treasurer's report? The chair recognizes the chairman of the ACC for a report under unfinished business. The first item of business is the motion relating to such and such, which was postponed to this meeting. The question is on the adoption of the motion. And the next item of business is there any new business? And finally, there being no further new business, the meeting is adjourned. So those are just some wording for the examples for the presider. Motion should be written down before it's put to a vote. If motion's offered verbally, the chair can either require the maker of the motion to put it in writing or the secretary to read the motion as the secretary wrote it down for the minutes. If amended, the chair could also be writing it down and just reading it from what he wrote down, but someone's got to write it down. It's got to be written down eventually because it's got to go in the minutes. And if the chair didn't write it down, the secretary should have, and you get the wording as written down to put before the assembly. So at any rate, if amended, the wording for the final vote should be repeated before that final vote. And if the chair doesn't have that, you can ask the secretary to read it. And it's only the final wording that goes into the minutes. You don't need the original wording. There are usually 6 steps to processing a motion. Member makes the motion, another seconds it. The chair states the motion, which puts it before the assembly for debating. And after debate, the chair puts it to a vote. And after the vote, the chair announces the result of the vote. You don't simply put it to a vote by saying all in favor, say aye, all opposed, say no. All right, next business is, well, you forgot to announce the result. All in favor, say aye, all opposed, say no. The ayes have it. Announcing the result consists of 3 parts. The ayes have it. The motion is adopted. That's part 2. And we will have our annual picnic on whatever date you just decided. The actual result of the vote. All right. That's it. Do you have questions?
Any questions here from Paul?
One second.
No, Paul, we don't have any now.
That's good. Thank you.
All right. Good. Thanks.
Thank you very much. I appreciate your time tonight.
All right. Have a good night.
We'll be in touch.
Okay. Bye-bye.
Thank you.
Thank you.
We're gonna move on to item number 5. This is the draft board meeting minutes for 12/12/2024. We got a motion?
So move to adopt the minutes from 12/12/24.
Thank you, Rob.
Second,
Thank you, Linda. All in favor? Aye.
I,
Good. I assume no one had any corrections there, correct?
Lori,
no
we
corrections.
heard Lori.
Lori?
Yeah.
I was not at that meeting, so I will abstain.
Thank you. Everyone else is in favor, right?
Correct.
Okay, it's just, we're barely at a quorum.
Uh,
It's okay.
All right, thank you. All right, moving to approved, by the way.
Yeah.
Okay, moving on to item number 6 is reports. We have Michael will give us GM December report, followed by the storm recovery update. Well, Michael, whenever you're ready, sir.
Thank you, Mr. President. The December GM report is in your board packet, with all of the separate departments. And if the board has any questions, I rather than go line by line through each of the departments, I would say though that, the salient points are in there. We'll discuss the windstorm damage update and the costs, up to this point, and the project updates, though, we have each of the departments who reported those, and these will also be in the view. So in the interest of time, I think that if the board would stipulate to it, or if you have any questions that we can elaborate on, I think.
We'll just have one quick question for you. Anything in particular that you think we needed to point out that now, because I do see it's just a lot of reading material and stuff, we might follow up with you later, but is there anything that really stands out that you wanted to address in that?
Really, the one would be right at the end of the report on page 81. Look at the rainfall today. 64, almost 65 inches of rainfall for January 1 to December 31, 2024. That, you know, coupled with the bomb cyclone, I think it explains a lot.
That's 20 inches more than last year.
Yeah, that's 6 feet of water. So, but being this is my first board meeting, I do want to give you the detail, but of course, everything that you have in here, I've discussed closely with each of the department heads, and I think if the board stipulates to it, everything really looks in order. I'm impressed by their reports.
Very good. Okay, does anybody looking through your report have any questions for Michael on anything right now? And if not, we can always follow up with an email. Okay, well, I'm hearing none. Are you got anything else that you wanted to add, Michael?
Done on that subject
Okay.
with the windstorm update, if you want to move on to that one, President.
Yep. Yes, please, let's do it.
So, the chart on page 76 has been updated just a little bit, and I do want to give you the updates. The total tree requests, currently 244. 154 of those have been resolved by our team internally. So Mike Brock and his team have really been addressing almost 2/3 of these issues. So they've done a great job. Now I'm sure everybody's interested in the dollar numbers. So the actual hazard tree data as of, and I have it as of today, is $266,395 spent on outside vendors for hazard tree removal. So we got 266, and then Joel has given me the numbers for the roadside cleanup to date. And that's approximately 40,000. So we're a little over 300,000 right now. And you may recall that December 12th, the board did allocate up to 479,000 out of roads and out of the operations. So if, I don't know if you want to discuss where that number is, but if it did come to 479,000, it would be for $161 special assessment for each owner based on 3,119 lots, which would be $13.50 per owner per month. Now that, if we're at 300,000 right now, Mike tells me he's got 9 pending requests right now, probably out about another 30,000 of the totals. Now we're into 2025 now as well. So I'm seeing worst case scenario right now, we're looking at 350.
That would be much better.
Right, it'll be much less than the 479, but you know, I know that Joanne and the board erred on the side of caution.
Yeah.
And so we will have a more of a close update and finer estimate for you for the January 23rd meeting. And then the board can decide action item on how we go about approaching membership with that and what that number will be. But $13 a month to recover from, you know, what was, I mean, look at what's going on in Southern California right now. God forbid, right?
Yeah.
But in interest of brevity, those are the numbers, and I think they're encouraging at this point. So Thank you, Mr. President.
Yep, thank you. Any questions from Michael?
Oh, I do have a
Got one
question.
from Linda?
Yes,
So the last batch of checks that we saw were, before that, it used to be hazard cleanup and stuff, and you would see line items for when we had them come back day by day. Now we're seeing again individual lots. Do we know if these are the trees that were created during the bomb cyclone, or is it just stuff that needs to come down? Number one. Number two, we still have giant trees sitting by the sides of our roads. What's the plan for removing those, or are we just gonna leave them?
well, I'll answer the last question first. The trees that are being parked there that are owner trees, those are still gonna be owner's responsibility to take out of there. We're using Rawls and the most cost effective. And I believe that our trees, our roadside clearing from hazard trees that were common area and SBCA, we're caught up on ours. So in some respects, we're giving those owners a little bit of a chance also to work not only with Rawls, but because he's the best game in town, cost effective wise. But we'll follow up on that, and the main thing is make sure that they're parked safely, right? Most of them are stored correctly, so we're not gonna have them rolling down the hill.
Yeah, it's just, there's some, I know because I go to my daughter's house every week. And it's like, there's some that came down during the windstorm, and it's like they cut them off because they were over Sudden Valley Drive.
Yes,
But there's still giant trees. There have to be some that are as long as this room.
Yeah.
That are disappearing down into the woods that are still sitting there, and I just wonder, is there any plan for those, or where are we with that?
well, any of them that are roadside, that are in the road right of way, or, those, and they are owner trees, we're giving them a little bit of a grace period, right, to get them out of there. But
I'll
we-
have to look and see if it's green space or if it's lots that are just vacant lots that are owned. I'll look. That's a good, thank you for reminding me. I need to do that.
Your first question, Linda, I apologize, was,
No, I was just wondering if, the only thing I had noticed, like I say, is in a lot of our bills, it has to do with, it definitely is street cleaning, or it's cleaning up like the trees at night. When they came out here and helped us during the
oh,
night.
yes,
But now I'm seeing again individual lot trees, and I'm wondering, are these trees that came down during the bomb cyclone that were getting the list, or are these people that were just on the hazard tree list? That's all.
right, great question, and we had, before the ACC, the arborist out speaking to this. And the 9, I know that the 9 that Mike has pending, those have been identified as compromised from the wind event. And so going forward though, we do have a blend before the event, right? Hazard trees that were removed as part of the normal budget. So,
Yeah, that's what I was gonna say, because part of that is normal budget and part of it should be capital. That's why I'm asking.
Yeah.
Okay.
And I do have an encouraging report to give you, all of the wood chips across from gate 5, that huge pile. We actually have a contractor interested in those wood chips, and his firm will be hauling them away at no charge to us. Not all of them, but he's
Are they gonna purchase or just haul?
right now, we're just saying take them.
Oh, I know,
Because otherwise we gotta haul them away.
it's incredible to see that pile of objects there.
Yeah, and Greg is also gonna use certain amount of them for golf lessons.
Yep.
But thank you for your time.
Thank you.
I think it's encouraging though that from a cost point of view, we're not up to the 480,000.
Thank you
Thanks for
very
your report, Michael. I really liked all the detail. Appreciate it.
You got, I wish we had better news for the people who have, their homes. near
Yeah,
the shore.
absolutely.
But there's something that came up. I asked for it to be put, because I didn't see it come through us at all. That's Whatcom County something or other that was posted on the website about people can apply. It's not, I don't think, as strict a process. And we put it in the views. I asked Tiny to do it. And it's interesting because that's the first I've seen anybody put any information. It was like copied online, but I don't know that anybody sent any information to the association.
This just came out from Olympia.
Okay.
Governor Ramsey's office signed it, so there is a needs-based component to
Yeah.
it to qualify. And for a family of four, you can't make more than $85,000-$90,000 a year.
Yeah.
So, but
Well,
it
there's
is,
lots of people.
Right.
Yeah.
Lost their property.
Yeah, there's a few programs out there, some of them are very hard to qualify for, and the one in particular you were talking about.
Seems easier and kind of, it applies to people who live in Whatcom County. It isn't all over the state. I think they separated it into like the ones down south, Snohomish, someplace else that has higher. But I think the thing that I saw is that specifically dealt with Whatcom County residents.
well, the latest proclamation, the one that was just approved by Governor Ramsey was for King, Pierce, and Whatcom. Those three counties.
But at least the information is gonna go out to membership and the views.
Okay, very good. Any additional questions or comments? No? All right, hearing none, we're gonna move on to item number 7, and I'm just trying to get a hold of our treasurer now, to find out, we have our finance committee member appointments. Not sure if we're actually doing that tonight. I haven't heard back from her.
I'm right here.
Oh, hi, Larry.
Tonight. I don't have any to offer tonight.
Okay, that's what I thought. I just
Yeah,
wanted.
I mentioned that several times.
No worries, no worries. We'll take that right off. So 7A will be deleted. We have nothing there to add tonight. We're gonna move on to 7B, the safety committee member appointments.
Safety committee has one,
Thank you, Tom.
and her name is Debbie DeVolio.
Debbie,
Yes.
and I assume she's been vetted?
I just got a text from Rick telling me about it.
Oh, so she hasn't been vetted yet.
We probably should confirm
well-
it.
Yeah, she has to be vetted, confirmed before we get appointed.
I would think he wouldn't put her forward if she hadn't been.
Well, it has to be confirmed by staff. I'm sure
We
you're,
can follow up on that. really
Yeah,
easy. We'll,
yeah, it's
we'll
not a
take
problem.
care of it and get back to you guys if we need it to be done further. Or have somebody look at it at admin staff.
and that was Debbie DeValio?
Yep.
DAVOLIO.
Yep, wow, I spelled it correctly. That almost never happens.
No.
I think she's Michael's wife.
Yeah, she is.
Or
All right,
related.
She
so,
was on the committee last year.
Okay,
So. All right, but she hasn't been vetted, so we do have to
Not
go
for
through
this
the
year, yeah.
process, so she's gonna have to be
Yep.
vetted. Was that it for you then?
That's it.
Okay, at this time, we'll have to bring her back when she's vetted.
okay.
Okay, moving on to item number 7C, Long Range Planning Committee. It wasn't an update so much as I believe it was appointments, is that correct?
It is, with Rick and Ray, both away, they've asked me to put forth 3 members, which have all been vetted. The first one is Gary Bara, B-A-R-A. The second one is Ken Vanderpolder, a little sketchy, but I hear that again. Mitch Waterman is the third. And they are also requesting, that Max, Robinson be their, staff person.
Max is, has staff liaison.
Yes,
That would have to be approved
That's-
through Michael.
but that is, they are
Separate.
requesting that.
Okay,
That's separate one, and we'll get that to Michael then. But that was their request, they need a staff person, and Michael, I'm sure will appoint members to that, but it's.
Long Range has a, I don't know, Michael, if you know, but Long Range has a special stipulation in their charter for their rules that they have a assigned staff person.
We'll get on that right now. Let's get our committee members added. So these have all been vetted.
Yep,
Okay, so we have Gary Bara, Ken Vanderpolder, and Mitch Waterman. We'd like to add to the Long Range Planning Committee. All in favor?
any objections?
Lori? I can see you.
Lori, do you
Are
have,
you okay with those guys?
do you have a vote, Lori?
Yeah, can you not see my? Cannot see?
good.
Yeah, I see it.
It's in now.
Okay, okay, yes, okay, I'll do it verbally.
There you go.
Sorry.
Yes, I'm okay.
I was trying to see if she did that.
Yeah.
So
So we need
you're
to.
okay with those three? You're voting yes?
Oh,
or-
yes.
Gary,
Yes.
okay, that's unanimous
Okay,
then.
that's unanimous.
Okay, that's on the long range planning committee. Okay, we're on now to item 7D, it's reinstate the annual marina contract. It's not actually reinstate the annual marine contract, it's the annual marine contract has been rewritten,
Rewritten, yeah.
had some changes
For
to it.
licensing contract.
From the one that's in your,
Tiny will present this.
sorry.
No, go ahead.
From the one that's in your board packet, I gave you a handout that has some very minor changes. Last minute, you see them highlighted in yellow. Last minute, we made a couple of little changes, just making sure that costs were put against the lot.
Do like the big reason, so the big reason why the changes were, we had some of them where Sun Valley was required, if there was an issue with the boat or something like that, Sun Valley would pull the boat out and tow it and do things like that. We don't want Sun Valley to be a part of that, so Sun Valley has the option to call someone to tow the boat, so we're not taking any liability, we'll actually call a professional person that does such a thing, where we don't have that ability to do it here. I know that was one of them, you had a few.
Yeah, there's a, I mean, well, but those were just the ones different from your board packet. And the general, we took out a couple of things. We kind of found out, Lori did some research, and some of the points that were in this agreement were taken directly from Squalicum Harbor, even to the point of all caps. So we took out, I mean, there was something about a 65-foot boat. That's not gonna happen here in Southern Valley. We took that out.
Thinker.
And like Keith said, we don't think that staff should be moving boats. We need to have someone professional do that. So we made changes to that. It was just all updating it, making sure that it made sense.
I have a comment, but should we wait until we have a motion on the floor? So I just give you the comment or
Well,
what?
You don't wanna discuss it now, you wanna have a motion, we certainly can.
Yeah.
It's just minor, but-
That's the way you feel more comfortable, it really doesn't matter.
Okay.
So the way the attorney described this before, if things are already on your agenda, and once you approve your agenda at the start of the meeting, technically everything on your agenda has already been basically like motioned and already seconded, so you can discuss it.
All right,
Alright.
go ahead.
Yeah,
guys.
so you can do one individual.
Okay, all right,
You're
I will do this.
There you go.
I
Make
make
the
a
motion.
motion
There you go.
to approve the updated licensing contract
I'll second it.
for Marina.
All right, there you go. Now we can start talking about
It's a
it.
minor-
I'm sorry, I'm writing at the same
It's a
time.
minor
I'm not.
comment,
Yeah, go
but
ahead.
it's based on experiences in the last few years.
Mhm.
I totally agree, and we decided about a waitlist fee. We do need to add a couple of words at the end of where it says apply to payment.
Where you at? Where you at?
I'm on the wait list.
Okay, on the wait list. All
On the,
right, so
on the
we're on the
chart.
contract first. Well, let's talk about two different things.
Well, I thought this was the.
No, you should have a part in here of the contract.
Part of it's the fees, part of it's just the wording of the contract. Right now, we're voting on the wording of the contract.
We have like an A and B here. So A, we're gonna do contract, B will be.
All right,
Yeah, that part of what you're asking is the letter to the, what, to the people that are, that's what that is. But go ahead.
I'll be patient.
Okay.
All right, so right now, we're just discussing the contract only, any changes to the contract. Did anybody have any issues with the contract? Part of the reason why the requirement is by wet slip, that was something that was in those, right?
Yeah.
There's no
Well, that
longer,
gets into-
there's no longer a requirement in the licensing contract that anyone who has a boat in wet moorage must have dry storage, must have a trailer and dry storage. So you
that
still
gets-
have to have a trailer available if you have to move your boat, but it's not required anymore.
So I
But that gets
request.
into the fees again.
Some request in the future, no big deal, just in the future, when you remove language from our documentation, would you please just have strike through in red, so I know what's been removed? Just please. Okay. Go
Yeah,
ahead.
Rob, this was almost totally rewritten because the old contract was the duplicate of the Squalicum contract, Squalicum Harbor contract. So a lot had been done and it was almost impossible for Timey to go back and,
We changed it a few times.
yeah.
Cool.
The attempt, Rob, was really there. But it didn't happen.
That's cool. I just requested, because I'm used to usually reading documentation where it's scratched.
Yeah, we took out probably how many pages, Timey? We reduced it down by almost 2 pages
Yeah, there's all that capital.
by taking out all the erroneous
there that was so
verbiage.
ugly.
You mean my 65-foot Donzi's not gonna be able to be?
No. But my 110-foot luxury motor yacht will.
Right on.
Just kidding.
The other reason we did it this way, Rob, is that in the past, on the front letter, we used to send out these contracts in, I believe, April. Now we're doing it, we're trying to get them out for January 15th, so we just wanted to get this so we can vote on it. And
Where is that sheet? Go over that.
the first one,
Yeah.
first page.
Yeah,
is-
go over this.
That's
So
the
yeah, so
letter.
here's some of the changes now. So the idea was before, where's the old one? I brought it with me to compare. I was confused too. So looking at the old one. You can see our old requirements for the key dates to remember was March 1st, started the SDTA, started accepting rental agreement for renewal. So what we've done is change that to January. So trying to change, to get on board with everything. So May 10th used to be the last day for you to renew your rental agreement for wet storage. We've now changed that to February 28th. So it's moved everything up several months. So you can plan for your summer, then we can also give us time, if you're not gonna rent your slip, it gives us time to rent that slip out. Like last year, we got some slips rented out, but like after summer. By the time we knew they weren't gonna be available and, by the time people legally had their time to get it in and us figure out they weren't renting it, we didn't have time to re-rent it. So we're trying to move everything up so they give us more time to get everything done in a cleaner manner. Perfect. Anything else in particular on here? Everything else pretty much stayed the same that I saw.
That was no, that letter was just mostly dates.
Yeah, and then I think that was important. Go ahead, Tom, you have a question?
Yeah, so this is the new agreement here in contract,
Yes, and that's identical. That part didn't change.
so it's too early to say how many dry parking spots is gonna be available.
I was told 13, but I don't know that. I'm not sure how that became available. I'm still not sure I buy it. I don't think there's gonna be any change.
You keep me back here.
Oh, is that mine? Okay, yes, all right.
Yeah, my only comment is in number 13.
Yeah.
That one's.
If somebody's on the wait list
Go ahead.
and there's no spot available, I really don't have a problem with them parking a boat in that way. But, what are they supposed to do?
Well, that's a board decision, not a personal decision, and a lot of people have issues with that. So we are an HOA, parking your boat in a driveway is unacceptable because it's an RV. And then an RV also is an RV, it could be a recreational vehicle of any kind, and who decides what's pretty and what's not? Like I've heard people say, well, my boat looks good. It looks good to you, it doesn't mean your boat looks good to me sitting in my living room looking at it parked in front of your house. So that's why it becomes issues. But go ahead.
I'm just gonna say it is in our rules and regulations. They can't do
It's
it.
been forever and a day.
I know, it's just a hardship for people.
We understand, but
It's hardship for everyone, anywhere you live, actually. Before you buy a boat or an RV, you should always consider where am I gonna park it.
I could take you to properties that have had boats out in their front yard on the grass for the last 12 years. That have never been down in the marina. It's not fair to those of us who are
Living
following
in
the rules, in my opinion.
Yeah, and there's cars parked in your, that's up to the new compliance.
That's right.
And
So
hopefully now that we've got that in place, it's gonna work. One of the things I wanted to say that was changed in here that I think was good. Is there's a number 9 that says that any vessel, and Lori can help me with this. Moored at the marina must be completely without hazardous conditions as determined solely by the association. And ready for cruising in local waters. It used to say that we would board their boat. And no, we're not gonna get on anybody's boat. But that says the association may require that the customer provide at no cost to the association additional information such as a marine survey to establish seaworthiness.
Part
In
of
other
this-
words, we're not, you know, if it was on there that we could go on their boats and you can't say that.
Some of this also came from back when Bob and I were volunteers down there. And you literally could look, when we would be out doing
Yeah.
something, we could literally see the canvas was completely frayed and destroyed. There was oil laying in the bilge. It was literally, there was oil stain laying behind the boat. Some of that was just that. And I don't mean to take much time, just giving you some context. The question was, do we want to be a storage facility? Or do we want to have an active recreational facility? So if we're just gonna let anybody in any condition store.
Yeah.
That kind of what you're saying, Tom, prevents Linda that really wants to be involved in boat, that keeps her out.
Yeah.
Right? I have my opinion but we're the Parliamentarian and Rich, I'm not gonna take up much of your guys' more time about it. Because it's not on the agenda, but some of this stuff came about back when we were asked to volunteer down.
Well, hopefully, anything that's in the water, 'cause that's like another part here where it says any fuel or oil that is spilled to the marina must be reported immediately to the rec center or administration. There was another entity that it's like, there's no way anybody's gonna do that.
So back in the day when we were volunteering.
Yeah.
We had just basic contact information when there were times where someone would say, hey, that boat's cut loose. In fact, this year I saw a boat that was half sunk.
Yeah, after the windstorm.
And unfortunately, the offices were closed. Back in the day, we would tie it off, or I would call like, hey, Tommy, your boat's half sinking. Well, I'm up in Canada. I only said because a lot of times it was Canadians, and we would, a couple times even through portable bilge pumps in there to help them out.
Which is different than boarding it just to inspect it, as she was saying,
Yeah,
like, you know,
that's
cause they're gonna
the whole-
open, they could, you know. Before, the
Oh, no.
association could start pulling people's covers back and
Yeah,
mucking around and then all of a sudden rain's getting in, and we just took that.
and we're just saying that's just something that's risk on the part of the association. And could
Right.
probably be sued for getting onto somebody's
I'm
boat.
not saying that anybody should climb in somebody's
Yeah.
boat without permission.
I'm just saying, there's stuff in here that was real.
I'm gonna pull back because I'm grinding a little bit of the hacks here because I think things were safer down there in the past.
Is there any further discussion?
Yeah, yeah.
Just of the contract now.
All right, so Linda, I'm gonna have you
Okay,
reread your motion for item 7D, number 1.
the motion is move to approve the updated licensing contract for the marina.
And I seconded that motion.
Yes.
We got our comments, ready to vote? All in favor?
Laura, you good?
I am voting in favor.
In favor.
Perfect, so it's unanimous. Thank you, Lori.
Thanks you guys for revising it.
So next, I'm gonna read the next one too. So now we're gonna go to the letter, but only a portion of the
So
letter.
we're still on item 7. This will be item 7, number 2.
Two, yes. There is the marina fees. And what I'd like to do is I would like to make a motion to reconsider the 2025 marina rates to include wet slip only rates.
Can I just speak on that, just?
Waiting.
Oh, I need to.
Sorry,
Second me,
Second,
All right.
sorry.
That by Linda and seconded by Tiny. Okay, now we're open for
Got ahead of
discussion.
myself.
There you go, see, Rob, we're good now. Open for discussion now.
Okay, sorry about that. The reason we wanted to put the annual wet slip moorage back in is when we revised the contract and we said Sutton Valley should not be moving people's boats and we'll have a company come in, then we realized that those 13 people that have wet only, they don't need to have their trailer down because whatever company we may have to hire will deal with that. They're not gonna go find their trailer. So if we took out the wet slip only, we would lose 13 dry slips because now we would force those people to take a dry slip. So by reinstating, by changing the contract and reinstating the wet moorage only, we again free up those 13 that we would have had to otherwise take away out of the mix.
In theory, it sounds good, I still don't know. And if I hear it like 900 times, I'm like, I'm not still sure how to work.
What you just said makes sense.
It does.
It
See,
makes
but I
Yeah,
think,
you got it, that's good.
and I think Rob had some other comments about the rate, correct? Am I-
Just one comment, it's not about the money, it's about, I'd like some additional words added in the wait list.
Mhm.
Where it says, apply to payment when contract is signed. Forfeit if member declines the slip when offered. I understand why that makes perfect sense. I don't have a boat, I just went on the wait list, drop me down, I get that. But we have a very succinct configuration of our slips with the ARC. There are a number of people who, me included, just to be transparent, who have boats that will not fit in the slips that were offered to us. Like I was offered a slip and we tried, we waited a day or so to try it, it just wasn't gonna work. And so we said, well, we'll wait until something that works out fits. So I would like some language put in there where at Sun Valley, if we as an association offer our members something that the configuration, well, I refer to say the configuration of the marina or the length theme of the boat doesn't fit. So it could be something as simple as just saying, unless the length beam of the boat it cannot be safely more than that slip.
Well, let me ask you something then, Rob, because I understand what you're saying totally. I've actually been in that scenario where I had a boat next to me, I could not, because I kept hitting my boat trying to get in and out of his boat, we were just too tight. So, and if you're on a wait list, right, say, and sometimes like, I waited like two and a half years, I think, to move to where the slip I'm at now, was about a 2.5 year wait. What was I gonna say? Oh, what happens, so you're on a wait list, you waited for that slip, you get a slip, you go up there, you're first on the wait list, they call you, you go down, and it's not a slip that's appropriate, it's not gonna work your boat. Do you go to the bottom of the wait list, or you say, no, I can't take that boat, you stay in your order?
No, what REC should do.
It just goes to the next one.
What REC should do is look at the configuration of the
Yeah.
boats that are in the marine. And move boats if need be to make the best use.
That's what we did with,
To make best use of our asset. So we may need, Tom and I we love being next to each other, but I may need to move next to you so that there's more room for someone.
Yeah.
We gotta manage the asset a little better and if REC, and I mean this in all respect, Michael, I mean this I do. But it could be that some people may not have all the expertise with docking, or maybe they haven't even docked, but maybe ask for some advice. Ultimately, the decision is yours. It's yours. But there could be people are willing to help. And most of us, if you ask me to move because it would help to make room for Tom, I'd do it in a heartbeat, as long as my boat's not gonna get damaged or something. I'm not gonna go, this is mine, it's been that way for 12 years. Heck, when I was Vice Commodore at Des Moines Yacht Club, we were moving boats all the time. I mean, because we had to, you know? But don't get me wrong, with permission, you know, we just go climb on people's stuff and all that. We just have to manage this. And so when I read this, that just says, you know what, I offered you slip 42, which is the second slip over from the gangway. There's no way my boat's gonna fit in there. Oh, sorry, Rob, you forfeited your money, you didn't take that slip, you should have figured out how to make it work.
And that was the intent, the discussion was, and you're right, the language needs to be in there, but you know, it was with the understanding that if your boat doesn't fit, that doesn't apply, but we can put that language in, I think that's important.
It protects the tenant, and it protects Michael's staff from someone coming down going, why didn't you kick Rob off the list, man? He didn't take that slip. Well, too bad it doesn't fit.
Anybody have a
How about,
So you're adding it?
how
Okay,
about
yeah,
something, Tammy, like if the boat fits the offered slip?
when offered, as long as the boat.
Stop.
That one?
If signed, forfeit if the member declines the slip when offered, if acceptable. But if it's
No,
not, then
don't-
they get to keep
don't-
the money.
Don't put it if acceptable, because that makes acceptance by both parties. You were gonna need to put something like, forfeit it if member declines an appropriate slip.
When offered appropriate slip,
Appropriate slip. And what really, I'm here with Rob 100%. When we had, when we have those slips and they were labeled, you know, like standard, premium and select.
Yeah.
And that was because we had empty slips and people could choose to pay more to have a slip that was more convenient. So you might have had a tiny, small little 4-person speedboat, but you wanted to be on the end. So you would pay more for what's at a select slip because that was something that was available. What we probably need to do, and Rob, you would be great, you know, with this, is take all of our boats and take our slips and say, okay, this slip is appropriate for X size of boat. This fits a boat up to 16 feet. This slip boats to 18 feet. This is a 20-foot boat. And then when boats come in, make sure that they're in the appropriate size slip.
You're right.
don't we
And
also
that could be some
number on-
reshuffling this one year. And some people aren't going to like it, keep them in their slip if possible. But some slips, like exactly like my boat, we went from a 16 to a 20. And it our door opened to the water. And we had to switch because you would fall in when you got off the boat. So people do, you know, our neighbor switched with us. You know, we didn't switch on our own. We went through the rec department. But so there might need to be some reshuffling of boats down there. And that would have to be, I mean, I don't know that if Kyle has all that expertise, and he might need to rely on an experienced boater such as Rob or one of the other people we have in the valley who can help and take a look at that. That's not going to affect our renewal, but it might be a project, a fairly quick project that needs to happen this year.
It's not real big, but you said it exactly how I see it too, Lori. It's the configuration, the piers get wider in certain places. They're all 20 foot long.
Smaller thing length, they just.
It's the backup space.
Yeah.
You might have a 20-foot long slip, but if you only have 6 feet before you hit the whatever it's called, yeah, it's gonna be really hard to get your boat out of there.
I mean,
Can I keep it simple and just at the end, unless their boat will not fit in the available spot
Safely,
Just
safely?
I would add safely.
Yeah,
tough, who's gonna determine that?
what are you gonna write instead of appropriate slip?
well,
Well,
unless
here's what
their
the
boat
driver-
will not fit in the available
You know,
spot.
here's the thing, you could just leave the same wording as is and have a discussion, like with the boat. When someone comes up, say, hey, you know, have a discussion. And if the boat is a fit for the open slip, then you make the offer. If it's not, you don't make the offer. They stay where they're on the list. You don't need to change any wording.
That's the other thing we could do is instead of changing it on both of these. Tell me, Lori, if we say decline slip without offer, then you put a star there, then you put down below here on the list. This whole thing, then just one sentence for both of these things that says unless the will not fit the available spot.
Yeah, but a slip must be appropriate for size of boat.
Right.
Oh, well,
Yeah.
so I think they're always gonna fit, really.
You just say slip must be appropriate for size of boat. You know,
The slip lengths are all the same, the problem's just gonna be the width.
right, it's the amount of water behind the boat.
Yeah,
The other problem is, did I jump in front?
No,
Because
you're
I've got
right.
about 5 bites of the
You're good, yeah, you're good.
The other problem
If we get
is
to
they're all 20-foot slips, and there's more room out on the ends because the arc.
Yeah.
But closer, especially facing the turnaround, like where the dry slips, that little point that sticks out where there's dry slip, and then it separates the wet, two wets. And close, going in towards that turnaround, there's no room to come out of there, especially when the water level starts to drop.
Back into the tires.
I mean, it's a 20-foot slip and there's literally about 8 feet between the end of the pier and it's just small, a little 18-foot boat. Yeah, they probably make it okay. They'll be okay.
That's what I used to have in there, actually, 18 and a half, fit me, but I got bigger, you're gonna back into the tires.
But all of the slips that face out to the spit itself or towards Spinnaker Lane, those, if you'd offered me a slip right next to Lori, I would have been there last year, or because there was plenty of room. I just was, it would be like, you've seen the cartoon of the guy like running into the car in front of him and running back, trying to get out of the spot, parking spot. That would have been literally me, and I'm not gonna do that to myself.
I think there was someplace on one of those lists that I looked at, because for a while I looked at them. And people had whether they wanted to be on the outside, is it called? Or and actually in the whole description of the boat and the request, it says what they're looking for. Do they need a select, do they need one of those ends? There's only 4 of those.
Well,
but I'm saying people actually, there's actually notes that somebody's gone to the trouble to put in there.
What we're saying is, and I mean is, I'm not trying, Kyle he may have he may be tons of experience. There's people who want to help him, and I'm not, but what I'm saying is we're identifying, we're kind of going off track because we're identifying a problem that Kyle's got and we want to help him. But this form should include length and beam and WN numbers. Because if I called Kyle and said, hey, this boat's sinking, it's a wide boat, I can't quite see out there, but here's the WN numbers. He could look it up in his database that way.
So you're saying the form that they fill out should include the information, this form that we approved should have that added?
We got a spot for an AIS. We got a spot for an AIS.
That isn't on there anymore.
But you need the WN number. And the AIS, oh man, there's so many.
Oh, it's here. It says vessel information, length, type, and makeup.
Length and then beam width. Because
A lot of people don't even know the width of their beam.
well,
But I know exactly.
We'll measure if they need help.
And the DOL registration.
Yeah, all
Their
those ones
it's all there.
Yeah.
We can add the beam width down there. I have no complaint with
It
that.
just helps Kyle make decisions on if he's gotta move people around,
Because you could put a wide beam boat with a small boat, and that'll work,
Yeah.
on it in
So you
side,
could-
one cable side of
Beam
it.
width if known,
Those wakeboard boats are wide,
But
They
yeah,
just
if
move
knowing,
beam width if known, add on that.
not if known, what is it?
where it says year, length, type, beam
Makeup.
width in parentheses, if known. And then make.
I'll tell them where to Google to go find out the manufacturer's information on the
Well,
boat.
I won't put if known, I'll just put beam width, I'll make that, and then, I think with Linda's suggestion on this, I'll do an asterisk so I can explain it a little bit better.
Yeah, and
You will not lose your spot if your boat does not fit in the available, if your boat cannot,
That's fine.
you cannot fit your boat in the offered spot.
No,
Make it a little longer. I'll put an asterisk.
In different color font.
yeah, something larger a little bit, there's room to do it.
Okay, Tom?
Tom's got
He's
it.
been trying for a while.
Sorry, Tom.
Could we solve a lot of this just by putting a disclaimer in the contract saying Sun Valley reserves the right to rearrange the slips if the need arises?
We have-
used to
Oh, that's
have.
already in.
We have to
there.
have that in
It's
there,
in
the
there.
right to move boats if necessary.
Yeah,
That's in the contract. What I have a question for, that I wanted to ask about and see how you guys feel about it. I didn't know we were gonna talk about other things on here, so if we're gonna talk about the waitlist situation there, I have an issue with the waitlist fees in particular. I don't mind $100, I think that's great for a waitlist fee, that's fine, but I don't think the full $100 should go towards your slip. I think $50 to stay with admin for their staff, for keeping the wait list and for doing whatever paperwork they need to do to maintain that. So I think you would put $100 down. I want a wet slip, you're gonna put your $100 down. $50 of that would go toward the slip, dry slip or wet slip, whatever you're waiting for.
So 50% applied to payment,
Yeah, that's what
50%.
how do you guys feel about that?
I think it makes perfect sense.
I'm okay with that. I can put
You
that
can do
in.
that as another
I can just
thing
put
at the bottom, do it at the bottom.
I can just
Well,
put, I can fit it
yeah, we're
right here,
making changes.
50% applied. I can put it right in here. It fits lovely.
And then I
But
have.
you're gonna do it for both of the ones or only
I'll
the,
do it for both.
Oh,
that's what I
Since we're on
said.
it, I might as well keep going, I have a couple others, and these are just questions, I'm sure you got answers for these, Tiny. So the annual dry marina storage, $600, that only increased $45 over last year, is that what you wanted? And then the kayak rack storage didn't change at all, it stayed this exact same.
that was what we proposed and was accepted.
Yeah,
And the same for season pass one card, stayed exactly the same, no increase.
no, I think that was update, I think that was increased for non-members.
We did vote on all of those numbers.
I know we voted on them, but we voted on the wet slip, how it's written
Sure
too, but.
Okay, let's
So I'm
do
just
it.
curious, we can change it at any time, it's actually in the contract, so.
Yeah,
So.
Hang on.
The finance committee, when they reviewed when they reviewed all the fees, because of the steep increase last year, they recommended no increase. However, that was overridden by the board.
They recommended no increase for which one, Lori?
They did. The finance committee recommended no increase because of the steep increase the year before.
For all those ones I just mentioned, the annual, the kayak and the season pass?
Yes,
Okay,
yes.
cool. Thank you very much. Okay, so then, all right, thank you.
The board voted, I think it was, almost every-
November, at the November meeting on
Yeah.
all. The only
they voted
thing
on all of them.
vote on was the annual wet moorage only.
Perfect.
Yeah.
All right, and Rob, you have your hand up, sir?
Well, I forget now, so,
Good, perfect. Just kidding.
you know me, I got an opinion on it.
Okay, do we have any other questions then on the change for the annual wet moorage only to add that to the marina fees as well as the change to the waitlist fee for the language? And I'm gonna have, Linda will read the motion, so we're clear on it.
Just a minute.
Yep, no worries. And then we are going to also change that language to require 50%. Right, of the deposit.
yeah, so that changes
And make
as,
sure Linda's got that.
yeah, changes as
So
discussed.
it's 50% of what?
50% of
Apply.
applied
Of your waitlist.
payment when contract is signed,
Applied to. Okay.
when contract is signed.
Yeah, 50%. Good, perfect, yeah. 50%.
All right, here we go. So once again, I move to reconsider the 2025 marina rates to include wet slip only rates and waitlist fee language, 50% applied to payment when contract signed.
And then we also had the asterisk about the boats fitting.
Ooh.
And changes
No.
discussed.
I'm wondering too, so this is the fees and it's just saying that if you decline it, you lose it 50% if you take it. When they go on the wait list, there should be a whole nother wait list, not as elaborate as this, but another wait list contract. And in that contract, you can spell out the terms of the wait list. So it could go into much more detail than this little box. It could go into detail as on what's considered an acceptable slip, what happens when you decline, because this doesn't address, it addresses you lose the fee, but it doesn't address you go to the bottom of the list and you have to pay another fee. So I think that you've got a two-step here. We're voting on the marina fees. We haven't even looked at. And that's probably something that the recreation manager should put forward, is the application to go on the wait list.
I think I agree with you, Lori, because this is something new. I think I agree with you that it's a whole new form
What's
Yeah.
the one?
For the wait list.
to go on the wait list, real simple. But it's a form that if,
Piece of paper.
I know,
I
but
guess.
you know what I'm saying, because it's like, did you sign that form? Well, no, I just told the guy down at the rec center. Then what did the guy look like? Well, he had glasses and short.
Well, that's
You
what
know,
I'm saying,
we need a form.
50% of it needs to go to the admin because it
Yeah.
is.
Yeah,
Yes,
it should
I
be
agree.
really, it should be really simple. It just needs to be the same, the license agreement, the first page, boat owner information. There's no reason why that same information should not be put forward when you're getting on the wait list. What is your vessel information? If you
Right.
don't have a boat yet, then you just put NA and we know you don't have a boat. And then where it says license terms and conditions, that would simply be wait list terms and conditions. And it would be,
Yeah,
you know,
you're right. And then a real simple thing of what the wait list.
yeah, one paragraph can
Yep,
say it all. It's not-
absolutely, and a
it's not rocket
signature and a
science.
date.
Right.
It's something I am absolutely sure this is something that Kyle could come up with very quickly.
Easy.
Pass it by
absolutely.
Michael. He can throw it to us if needed. I don't even know if it's needed to go to the board. It's not it's just it's an internal procedure. That, you know, that's my suggestion. I think that's up to Michael and Kyle to decide if that's appropriate.
Just a quick suggestion, I'll throw it out here. If you put 3 or 4 bullet points at the bottom of the, right here, underneath the wait list and outline those. That these apply to the wait list. 50% of your fee will be applied to when the contract is signed. If the slip is appropriate for the boat, put those in bullet points right underneath it on the marina fee schedule. That, to me, it just saves one more form,
Yeah, absolutely.
but.
So Michael, right now, if you look at the wait list we have, sometimes all it has is a first name and a phone number.
Yeah, you
Correct.
really need to look,
That's it.
Well, the idea would be that we would more formalize it, change it into something that's,
Yeah, exactly.
and have more than that on there, you'd have a name and address, they paid a dollar amount, when they paid it, you know.
like now, somebody will say they're on the wait list, the guy's name is Chad.
Yeah.
Yeah,
Go ahead, Rob.
what's his phone number? I don't know, what's his email? I don't know, but he's got a vote and he wants to be.
Or he thinks he wants to.
All right, Rob.
I was gonna make a suggestion and tell me if this is getting into the out of governance to the management. But I would be happy to give Michael and Kyle a copy of the Des Moines Yacht Club wait list agreement that we put together, worked really well. It's a club like an HOA. It's a private organization, not Squalicum. If Michael, if you'd like that and you guys want to build off of that, I would be happy to send that over to you.
Sure, the only thing, we have the 15th coming up next year.
Yeah.
I'd have it to you
I'm trying
tomorrow.
to push this out.
We don't have to have that in with that, with
It
this.
doesn't have to be done by the 15th. That's because that's just the waiting list fee.
It'll be done, yeah, the,
Yeah.
we can still put the
The
notation.
little, yeah, the little
So
bullets at
people
the
see it
bottom.
coming, but, the wait list, we have time for that.
Remember, there's also Chat GPT. It works really quick.
All right, so Linda, do you want to finish your motion to add?
Back again, we're
Okay.
trying this, okay? Motion to reconsider the 2025 marina rates to include wet slip only rates, wait list fee language, updates, and changes as discussed.
Second,
Perfect, so that's Linda. Second, okay, all in favor?
Me.
That's unanimous. All right, very good. That's 7, that was 7, item 1 and 2. Now we're on to 7E. It's a capital request, golf maintenance equipment, Michael.
Thank you, Mr. President. I'll handle this with Greg. This is on the capital expenditure budget. $60,000 is allocated there. Greg is recommending, and I concur with him, the Wiedemann Terrace pipe, the XF6. They not only have demoed it, but it's under budget, and I think it's a great piece of equipment. Now, we did have, the finance committee didn't have a chance to approve this, yeah. So any of his further capital request this year, we're gonna, of course, run it by the finance committee first. So Lori, this one, and for the board edification, again, this is a little unusual, but the piece of equipment is in the shop. We don't want to send it back and then have them delivered again, because we'll have to
Okay,
pay for the
All
delivery.
right, so I'm gonna read the background on this. The Ryan aerator was purchased in 1980s and has come to an end of its useful lifespan. The Ryan aerator is scheduled to be replaced in 2025 with $60,000 allocated in SURF. This piece of equipment is a key part of our maintenance fleet that is used throughout the season, ensuring our fairways are maintained through firm draining surfaces throughout the year. Proper draining fairways through deep tine, deep tine aerating plays a key role in our shoulder seasons, spring, fall, and winter. Many golf clubs are judged, reviewed, or commented on social media on how well they play, firm and dry, or wet and soggy, which leads to either an increase or a decrease in revenues. The continued practice of deep tine aerating will continue to improve playing conditions at Sudden Valley, thus improving profitability long term. Analysis. The unit is scheduled for replacement in 2025. The 3 manufacturers asked for quotes to replace it. The recommended equipment and prices are summarized on the table below, and there you can see the manufacturing models, the Toro, the Biedermann, and the Verde Grain. And the prices. All right, after reviewing the quotes, equipment knowledge, reliability, and speaking with colleagues currently using various models, we recommend the Wiedemann Terra Spike XF6 model. Parts replacement for various soil conditions throughout the golf course, servability and usability on our property were key factors leading to the decision of this model. So the motion is move that the board of directors approve the purchase of the new Wiedemann Terra Spike XF6 aerator and allocate $57,495.36 from SURF.
second,
Thank you. That's Keith, that's Linda.
I just
Okay,
have,
open for discussion, question.
I just
Go
have
ahead,
one
Linda.
question. What are they gonna do with the old one? Are they just gonna junk it? Are we gonna? Do we know what we're gonna do with the old one?
At this point, the salvage value is unknown, so we'll be storing it there at shop and until and if we can, it's at the end of its useful life, so. Unfortunately, it's not the same model, so the parts won't work,
Yeah,
but.
I just wondered if we were storing it, and sometimes you can resell them or either, salvage, then somebody will come get it. Cause otherwise we end up with, and it kind of looks like that now sometimes, it's here where we have all these rusting parts. I wish they would just ship them somewhere.
Yeah,
I have a quick question. When,
Greg on that, and we'll.
Okay, Lori has a
Lori,
question.
go ahead, Lori.
so if I understand and heard you correctly, Michael, the one that we currently have sitting in the yard,
The new one, the demo that's here?
the demo,
Yeah.
that was a new machine, and that is the one they will leave here and we will purchase?
That's correct, yeah.
Okay,
Any other questions?
that was it.
Wow, this is really good.
Go ahead, Lori. No, go ahead, Lori, still.
Yeah.
No, I don't have another question. I just wanted
Okay.
clarification because he mentioned that it would avoid us having to ship it back and everything. I just wanted to make sure that what we received was the actual machine, and because
Gotcha.
demo could mean anything.
Gotcha.
Any other questions?
I have no objections.
Okay, hearing none, we're gonna move on to vote. So the motion on the table again is to move the board of directors to approve the purchase of the new Wiedemann Terra Spike XF6 aerator and allocate $56,495.36 from SURF. That was motion by Keith, seconded by Linda. All in favor?
Lori, you in favor?
Yes.
I know, thank you, just
Thank you.
confirming.
All right, that's unanimous, Michael.
And whatever.
Okay, we have one last request. No, not a request. Item 7F is the appeals members. Jaime? Appeals committee.
Yeah, we do have an appeal coming up apparently on the 14th. And
6 to 7.
yeah, and so I need 2 members. Linda, are you still?
I can do it, I'm good until the 15th, when I have to drive.
Go ahead, we have Linda.
And
I need
Even
one-
better.
She needs one more. Actually, I need to
Rob
bring in
said
my
he could do
payment
it
for-
too. I talked to him and he said he could do it as well.
Yeah,
so-
who, Linda and Rob?
Yeah,
Rob Gibbs?
Rob Gibbs, he's coming back.
Yeah, he's coming back, yeah, okay, so Linda, Rob,
And Timmy, it's only three of us.
Yeah,
so we don't have to point Timing or.
Did you tell
Yeah,
him
I'm
though,
already on
Linda,
that.
did you tell him for sure when this first appeals is?
I haven't.
All right, we're gonna get a second, till Rob comes back.
Okay,
Yep, no worries. Give it a second. In the meantime, I guess we can let the board know. If the board doesn't already know, and I'm sure you guys do, that Nancy Alienak and Josh Bowen both resigned off the Long Range Planning Committee. Like a week or so ago. Is that correct?
That is correct.
Yeah, okay, I wanna make sure.
And it was,
what's her name
what's
is
her name? She
left.
left.
She doesn't live here
Barbara
anymore.
Wally was on as well,
Oh,
but she moved out of the
Well,
area.
she has,
So
yeah, she's
that's
moved.
why she's not on long range. planning.
Barbara's no longer on it either.
Oh, I love that music.
10 o'clock, time for me to go to bed.
Here comes Rob. We were waiting for you on purpose.
Rob, are you still interested in being on the Fields Committee, sir?
Yes,
Can you do it on the 14th?
Can you do one on the 14th from 6
January.
to 7, just around the corner here?
It'd be in this
so.
room.
Are you open? Be down here in this room.
14. 67, sorry to hang you guys.
No, it's cool.
Let's see.
How often do you
Gotta have
meet
three.
for the appeals committee?
Oh.
How often is that?
Whenever. we
Whenever it happens.
Hopefully not too often,
On the
Daniel.
14th, 6 to 7.
Yeah,
I'm there.
okay.
All right, very good. So we have appeals committee members we'd like to get appointed tonight would be Linda Bradley and Rob Gibbs. Both are vetted and good people. Anybody opposed? All right, so be it. So Linda Bradley and Rob Gibbs are now on the appeals committee.
All right.
Cool.
Alan will be happy, he's been asking.
All right, hearing that, we are adjourned.
At
We have
what
a
time?
motion in a second at 10 p.m.
2 a.m. Friday morning.
Although I have to say, considering
job.
all